By Senator Lombardi, Senate Bill 250 Sub A, an act, Senate resolution adopting the rules of the Senate for years 2019-2020. Senator Lombardi.
Thank you, Mr. President. Ladies and gentlemen of the Senate, thank you for allowing me to present the proposed rules changes for 2019-2020. By way of introduction, I would say to my colleagues that this represents a significant movement in the direction towards transparency. For that, I want to thank you, Mr. President, for being open to us to allow us to make these changes. And also, I want to thank your staff, particularly Richard Sahajian, John Pagliarini, and Lisa Cludia, for assisting us in not only drafting this piece of legislation, but being present at the Rules Committee meeting, and also for doing all of the necessary research to support what is, I believe, a very transparent piece of legislation. Now, what these rules, I want to put the rules in perspective first, Mr. President. One of the proposals in the rules, and I'll get to some of the amendments substantively, is to abide by Mason's rules of legislative procedure. For those of you who don't know what Mason's rules of legislative procedure is, it is the Roberts Rules of Order only for legislative proceedings. It is much more applicable to legislative proceedings than Roberts Rules of Order. And in that piece of material, this learned treatise, it sets forth that our rules occupy a very high level of authority from a legislative proceeding perspective. And what I mean by that is they rank all of the sources of law that we have here in the state of Rhode Island, and they prioritize them. And so based on Mason's and Roberts rules, the rules of the Senate are only junior in priority to constitutional provisions and the judicial decisions that interpret those constitutional provisions. So any piece of, for instance, any custom, any state statute, anything in this book contrary to our rules, and any parliamentary law that we may have, all are junior to our rules. Our rules are senior to all of those, and our rules will apply, and the only time they don't is when they conflict with a constitutional amendment. So, that being said, the proposed rules themselves have about 20 changes to them, but they are not all substantive changes. And if you would indulge me for sake of brevity, I would only go through those issues that are substantive and those that seem to have drawn some attention in the committee. So first, the first most pertinent item is in section 5.2. And 5.2, and if you're following along, forgive me because I'm trying to hold a microphone and get to 5.2, is entitled Committee Membership. And essentially, this section has been put in which provides that the President of the Senate, who is the presiding officer of this body, has the authority to remove someone from a committee for cause only. Those are the words that we use, for cause only. Now, I will point out parenthetically that for cause only is a higher and stricter standard than would be in Roberts rules or in Mason's rules. What it means in Mason's rules and in Roberts rules is that the Senate President could remove a committee member for no reason. In this case, for cause only is the standard that we have chosen to take in the spirit of transparency to allow the Senate President to remove someone if someone has done something that is cause-worthy for removing, so that we create a legislative history associated with these rules for the next 2 years. For lack of a better term, it's the Senator Kettle rule. Regrettably, Senator Kettle ran into some problems when he was here in the legislature, and our rules were devoid of any process by which the Senate President could remove Senator Kettle from any of those positions. So what this for cause only does, and there was some discussion in committee that the president can use this to be vindictive or to remove somebody for some reason that is not cause-worthy. Well, this for-cause-only language has thousands of cases on what for-cause stands for. And I will say to you, and I'll leave it at this, that the Senate president has the authority to remove someone from the committee if it rises to a level of conduct that is worthy of removal from that committee. It's not because you're wearing a blue tie today. It's not because you're using the bubbler. It's not because you don't agree with someone on something. It's for cause. And I would say to you that this is in line with our spirit of transparency. I would also say to you that it's a general principle itemized in our rules anyway, and in Mason's, that the presiding officer of this body has an inherent right to remove members from a committee. And so I would say to you that the Senate President, along with our staff, have drafted a piece of legislation that goes far beyond that. And you can look to both Robert's rules and Mason's on that issue. The second piece of legislation that was of significance in the committee is found at 6.18. And 6.18 is a no-brainer. What we did was we've improved our procedures in such a way that sub-A's, substitute bills, will now be posted 24 hours in advance. I will say to you that, and just say this, that received the overwhelming support of everybody that attended the committee, including Common Cause, which found that to be a significant improvement from our previous rules. Next is 7.1, and in 7.1, we have added the requirement that no senator speak on the floor for any period of time more than 5 minutes. I will say, first and foremost, that inherent in many rules, including Mason's and in Roberts, there is a right to a time limit. Time limits are presumed in many instances. The 5-minute rule, not that this is binding upon us, but the 5-minute rule applies in the House. But I would also enlighten everyone that the 5-minute rule is not a strict rule. First and foremost, the majority and the minority leaders have certain, they have an exception to this. The principal sponsor or the floor manager of the bill also is not bound by this 5-minute rule. And most importantly, any senator in this body can yield their time to another senator. So in other words, we can totem pole the 5-minute rule. So the 5-minute rule does not apply. And I would also say that the senator has 2 opportunities to speak. So on both of those opportunities, the 5 minutes apply. So in theory, because my math is horrible, if 10 senators yield to a senator to speak, that senator can speak for 55 minutes if they so choose. 5 of his own and 10, or her own, and 10 times 5. But then have a second time and be able to speak again for another 5 minutes. So any concern about that issue, I think, is inherent in our decorum. It's inherent in all the rules to have a time limit, and it certainly, I think, reaches a happy medium on that point. Next, there were some issues, not issues, but some discussion about 10.15, and again, I think this bill was heralded as a good portion to this bill, and I'm sorry, to this resolution, and again in the spirit of transparency, where it basically says that we are encouraging photographic equipment there unless the chairman of that committee deems that that photographic equipment has become a distraction to the committee. So in other words, if the photographer is blocking the means of egress and ingress into the building, into the room, excuse me, you have the right as chairperson of that committee to remove that person there. I will offer to you, and again I thank John Pagliarini for helping me, our parliamentarian. He cited the Attorney General case involving a case similar to his last name, wherein the Attorney General ruled that anyone has the right to record a public hearing. So we couldn't prevent them from doing that anyway. It's merely a distraction exception there. And lastly is Rule 10.22, which, in my opinion, represents a codification of past practices, but nonetheless warrants some attention. And in essence, it deals with the election of our Senate President and other officers of the Senate. And essentially, it calls for a roll call vote, as has been done since the inception of a Senate President to this body in 2002. I would say to you that efforts to try and create a secret ballot, I would submit, runs counter to the transparency goal of this resolution. We, as senators here, have always done this by open roll call, and I think that if we're going to be transparent, why would we want a secret ballot? On the contrary, I think that no statute can bind future actions of this legislative body. We're governed by the Constitution, our rules, and custom, and that custom has been around since 2002. And I would point out, every 2 years we have to change these rules, folks. We cannot bind future legislation. I would say that there's nothing more democratic than standing up and voicing your beliefs, including who you believe should be the leader of this honorable body. So, U.S. Congress, by the way, by analogy, does that by roll call vote. And I would say that every 2 years, members of the United States House of Representatives are called out one by the clerk and asked as a member to who they want to lead them as Speaker. This year, after nominations, 220 members rose to name Nancy Pelosi, 192 for Kevin McCarthy, and 18 members said other. So I firmly believe this is the transparent way of doing things. So I am very happy to have presented these rules. I think they represent transparency. There has been members of good government spoke in favor of these rules as amended, and I will eagerly move passage, Mr. President, and at the appropriate time I do have a floor amendment.
Senator Lombardi moves passage of the act. Seconded by Senator McCaffrey, Senator Lynch-Prata, Senator Goodwin, Senator Conley, Senator Filag, Senator Gallo, Senator Lombardo, Senator Sosnowski, Senator Chacon, Senator Crowley, Senator Casada, Senator Pearson, Senator Picard, Senator Metz, Senator Archibald, Senator Rogers, Senator McKinney, and Senator Coyne. Senator Lombardi, do you have an amendment? Would you like to offer that amendment now, Senator Lombardi?
I do, Mr. President. The amendment is LC 001115/8, and I would submit that there are a series of changes in spelling, apostrophes, and technical amendments. So I would move passage.
Senator Lombardi moves passage of the amendment. Seconded by Senator McCaffrey, Senator Archibald, Senator Lynch-Prata, Senator Goodwin, Senator Conley, Senator Chacon, Senator Sheehan. Discussion on the amendment. Senator Morgan. Not on the amendment? Okay. Senator Nesselbush. On the amendment. Not on the amendment. Discussion on the amendment. Not on the amendment? On the amendment, Senator Bell.
And I would just like to ask unanimous consent that we be given 2 minutes to read this amendment. Just so that we can read the amendment. Is that, perhaps this may be a great deviation from procedure, but I just want an opportunity to read this amendment to consider it. I think it's really important that we read the text of the amendments before we do so. So I would
I'll give you that opportunity, Senator Bell.
Thank you so much.
Senator Nesselbush, your light is lit. Not on the amendment. Okay. The Senate will be at ease for a moment. On the amendment, Senator Nesselbush.
Ladies and gentlemen of the Senate, again, I'm all for dotting I's and crossing T's. The only reason I rise is because part of it does involve the word electronic, using the I assume that I don't have the entire sentence, but I assume that has to do with the electronic roll call. So to the extent that that's it, I will be addressing that later in my remarks, but I am against the electronic roll call, so that's it.
Mr. President, I think there are some good changes here, particularly the change on line 16, excuse me, changing the word distraction to disturbance. I think that was a very helpful and clarifying change. Thank you, Mr. Chairman and others.
Thank you, Senator Sheehan. Senator Bell.
Thank you. You know, and again, I have not had full time to consider all this, but one thing that strikes me is the third part of it. On page 13, on line 19, before the language, the legislative, by inserting the language and. So currently, it reads, at least 48 hours before a standing committee meeting, a committee agenda containing the number, title, and a short explanation of each bill to be considered will be placed on the official General Assembly website, as well as on the Legislative Data Bulletin. The rule shall not apply to bills previously passed by the Senate and amended by the House. This would insert the word and I'm having difficulty understanding the grammar here. So then it becomes at least 48 hours before any standing committee meeting, a committee agenda containing the number, title, and a short explanation of each bill to be considered will be placed on the official General Assembly website, as well as on and the Legislative Data Bulletin. And I'm sure that there is some intent here, but looking at this from a grammatical sense, unless I'm misunderstanding how this works, it creates a sentence that to me is grammatically confusing, and I worry a little bit about that. But I do want to speak in favor of some of the other.
If I may, sometimes that crops up. There are transposition errors and misspellings. The Leg Council will fix that at the appropriate time in the event that this amendment does pass. So they make those adjustments in law revision. That's not an odd occurrence.
Thank you for informing me of that. Again, as a new senator, I'm not always familiar with these procedures, but I do know that we have the ability to make oral amendments. And so what I would like is, after I have an opportunity to speak in favor of some of the other changes, I would like to consider that. So I think that on page 27, on line 27, the language that deletes the language distraction and inserts in place thereof the language disturbance is an improvement. And this is very important because one of the big concerns I have with the current language is that it could be abused by a committee chair who doesn't want the media present to kick the media out. And this strengthens that language. And so now it would read, during sessions, photographic equipment that blocks ingress or egress or unduly creates a disturbance instead of distraction, it does still say, and determined by the President of the Senate or the committee chair, shall not be used on the floor of the Senate or in committee hearing rooms when committee meetings are in session. I think that this language improves on the underlying language. It doesn't fully ameliorate the concerns, but I think it's an improvement. On page 18, line 5, by deleting the language principal and inserting in place thereof the language prime. And I think what this does, and again, I've only had a little opportunity to consider this, but I believe this is designed to fully match the text of the House rules, because the House, I think, uses the language principle. And so that sort of consistency with our goal here that we're trying to do our procedure according to the way that the House does it. And I think that underlines that. I do think that may raise problems, but it's good that we be consistent. So again, I would like to return to that issue I raised before about the and I would like to ask if the sponsor of the amendment would yield to a question for clarification.
Chairman Lombardi, will you yield to a question?
Certainly, Mr. President.
And so my question is just, could you help us understand exactly the goal of inserting this and what the sentence would mean grammatically when it's put in?
Senator, to the extent that you're asking me about, you would mention you would itemize three separate issues, but if you're talking about page 13, line 19?
I am. Thank you so much.
So what the intent of that amendment is, as you recall, you were present in the meeting, you recall that there was some concern. In fact, some senators asked what the legislative data bulletin board was, and we were told that it's in the sub-basement near the policy office, and there was some concern about keeping in line. In fact, John Marion offered that we should always still use, you know, the library. So the intent of both that section and section 17 is to restore the language and add the word "and" there, and then also in on page 17 at line 23 to have the library again. So you will have two sources of posting, again, more transparent. Did I answer you? I hope I answered your question.
Yes, thank you. That does answer my question. You know, I had missed the first part that says restoring all the stricken language, and so that clarifies my question. And I think that in net, this language is probably an improvement. I'll be voting in favor of this amendment.
Thank you, Senator Bell. Further discussion on the amendment? The amendment has been moved and seconded. Clerk will please unlock the machine. If all clerks have registered, if all senators have registered the vote, clerk will please lock the machine. There are 37 votes in the affirmative, none in the negative, and the amendment passes. On the act as amended, Senator Crowley.
Thank you, Mr. President. I support this legislation, but I have to point out a couple of pieces that my constituency called me on. And one was bringing posters into meetings. I know it's allowed out in the hallway, but it's not allowed in the chamber itself. So I want to just point that out, that the constituent of mine says, well, you're taking away their amendment, their right to publicly display what they feel, because they can't get up and speak or something, they want to be able to display in meetings. I can see where it could become a burden, but it has never been displayed in our rules so poignantly as it is now. And so I want to make that, make our people here aware that the public likes to be able to express themselves, and it is a hearing room, and maybe we should allow it. But on the whole, I support this resolution. I don't believe that it gives you any more power than you already have. I like the idea for cause only, because if our hands were tied, as we said in the previous senator who had issues and problems, your hands were tied. So I am going to vote yes on this resolution. Thank you.
Thank you, Senator Crowley. Senator Morgan.
Thank you, Mr. President. Will the sponsor yield to a question?
Will the sponsor yield to a question? Senator Lombardi.
Yes, if I get some maple syrup.
They left.
You're sweet enough, Frank.
There's a section in here that mentions visual aids. I mean, will someone in a committee be able to bring in a visual aid to enhance what they're speaking of or testifying about as they're testifying?
If you can point me to the section you're talking about, Senator, I can probably elaborate a little bit better.
Number 17, paragraph 17? 1017. There it is.
Okay, we talking about the section that Senator Crowley just talked about?
Yes.
Okay. Remember, that bit you asked if a senator can use aids.
No, if anyone testifying in that committee can use a visual aid when they're sitting testifying, if they want to show a visual aid.
I would say to you, the answer is resoundingly yes. The prohibition, the discussion got to such minutia in committee that they talked about people wearing pins and stickers on their lapels and that sort of thing. The spirit of this rule, as it already is in our here in our chamber, is that signs and placards, because they are a distraction and people can't see. So obviously, with the permission of the committee chair, a visual aid is not that kind of a thing. It specifically delineates posters, signs, and banners on the floor.
Okay, thank you.
Thank you, Senator Morgan and Senator Lombardi. Senator Nesselbush.
Thank you, Mr. President, and ladies and gentlemen of the Senate. I rise reluctantly about these rules. You see, the truth is, I don't like going against the flow, and really, I don't like being, quote-unquote, against anything, especially a bill that is supported by leadership. And frankly, it's no fun to be at odds with people that I genuinely like our President, Majority Leader, our whip, and my seatmate over here, who God only knows what he'll put me through here today. I also want to let you know that I respect all of my colleagues and your time, and I would never take up this chamber's time except for a very good reason. And in my opinion, democracy is a very good reason. And in my opinion also, these rules raise important issues of democracy. But before I talk about what I don't like about these rules, I want to thank our leadership team and our chair of the Rules Committee for the important rule changes that they did make after the first draft came out. So particularly, I want to thank you, Mr. President, and your team for the 24-hour rule. Obviously, it's very hard, especially in the last days of the session, to be voting on bills that you don't have 24 hours or even 24 minutes, and sometimes not even 24 seconds to read and know what you're voting on. And I also want to thank you for reverting to the in order to change your vote on a bill without objection and with a majority of the Senate. So thank you for that. I'm also very happy and deeply grateful that you did add the word for cause to the section in terms of removing a person from a committee. But in terms of these rules, as we consider them, please consider that the Senate is the upper chamber and that we should be above the fray. As we begin a new session and we begin to get into the meat of addressing our state's problems, the Senate should embrace and exalt small d democracy and its protections of process of the minority party and of minority opinions. Businesses and taxpayers alike in our state are clamoring for a better, more accountable government, and we today have the opportunity to give that to them. In terms of small d democracy, I have often said that democracy is worth living for, and I think our brave war heroes who go off to war, and some of whom never come back, have also shown us that it's also worth dying for. You know, when they go off to war, they go off to defend what they believe is democracy that's happening in Congress and in state houses throughout the country. And I want to make sure that we here in the upper chamber are doing everything possible that we can to live up to their ideals. After all, that's who we are as Americans and who we are as Rhode Islanders. Like all of you, I ran for public office to try to make a difference. I've tried to do that in terms of the legislation I introduce, and now I'm going to try to do it in terms of the rules we enact. I want to try to make a difference for democracy. And the truth is, ladies and gentlemen, I never paid attention to our rules in the first 6 years that I served in this body. However, in 2017, when we had the first succession of leadership that I – participated in, I would call it a travesty. You know, all those years before, I must admit, I never read them and I blindly voted green. But then came that leadership succession, which literally made my draw drop. It happened so fast, and after it was over, I looked into our rules and I said, could this really have been in accordance with our rules? And I realized that at that time, last year, our rules were silent on succession. So perhaps I was naive in thinking that as an endorsed, duly elected Democrat, that I would somehow be involved in the process of electing our Senate president before I was essentially told that it was all over. But the truth is, I really wasn't involved at all until it was all over, and basically everybody told me a decision had been made. So from my personal and humble experience as a senator and as a member of this body, that all happened in one day. From one day to the next, in the dark of night. I remember I was actually at my good friend Senator Quesada's fundraiser, and in my opinion, it happened in a less than democratic way. And that's why I'm offering just 3 amendments today. Now, there are many amendments that I could offer. For instance, I want to tell you that I think Rule 6.5 is perhaps the most poorly worded regulation or piece of legislation that I have ever read in my life as almost 30 years as a lawyer, and it has to do with requesting a hearing. You know, for 6 years, I never had any trouble getting a hearing. Last year, we had a little bit of a sticking point. It was going late, and I looked at the Rule 6.5, and as a lawyer, I could barely understand it. And then this year, I tried very hard to comply with that rule, which basically says, ladies and gentlemen of the Senate, that you have to request a hearing on bills by the next legislative day after the period to introduce bills closes. Now, that period was the Thursday before we all went on vacation, yet of course every day, today I've signed probably 5 bills, we're all still introducing legislation. And in trying to comply with it, I asked my secretary, I drafted a letter as I was supposed to do, I mentioned all of my bills, and I went to hand it, as the rule requires, to the Secretary of the Senate, my good friend Bob Ritchie, and no sooner did I hand in the bill than somebody, a page, brought me up 2 new bills that had just come up for Leg Council and weren't even included in my letter. So the timing on that, and also now I'm getting all these hearings and I have, you know, people saying, well, you requested them, you know, that in order to comply with the rule, you have to do that. But then, you know, I also have no interest in making the chairs who have so much on their plate give me a hearing within 8 days. So I think that part of the rule is a little ridiculous. But I'm not going to go there. Somebody very wise had told me to pick my battles, and so today I will pick my battles. But I also want to say, and I'm not offering an amendment on this, but that I'm not in favor of the 5-minute speaking rule. I don't think that that has typically been a problem in this Senate, and it would effectively abolish a hardly used but very important long-standing tradition, which is the right to filibuster. And I wish, of course, on another note, that our rules would require the videotaping of all committee hearings, but alas, I'm going to focus on just the 3 amendments that I think are really fundamental to democracy. Mr. President, if we could, is now the appropriate time for me to offer an amendment, Mr. President? Now an appropriate time?
Now is the appropriate time.
Okay, so the first amendment, and ladies and gentlemen, bear with me, I've never done this, so we'll see how it works. I don't necessarily understand the technology, but the amendment is LC 00111-5/7, and I'm taking these in order. And so this has to do with actually what my brother, Chair Lombardi, talked about, which is Rule 5.2 for committee membership, 7/7.
Please hit refresh. Senator Nesselbush, apparently it's coming up with a /8.
No, it's 7 now.
Is it 7 now?
Hey.
Okay.
While you're on it.
All good things come to those who wait.
All right.
Does everybody have that?
We have the correct amendment in front of us that you're offering.
Okay. So ladies and gentlemen of the Senate, The reason I proposed this amendment is because the rules as proposed further consolidate power in terms of the ability to remove a senator from a committee with cause. They further consolidate that power in the hands of our Senate President. And as I have said so many times, I have nothing against our Senate President. I like him personally, and I think, frankly, we are on the same page on many political issues. So it's nothing personal against him. It's just that I'm not in favor of further consolidating power at the top. I think this goes against the ideals of our founding fathers, whether that be Thomas Jefferson or Roger Williams. In my reading of history, I know that Thomas Jefferson was deeply afraid of the consolidation of government power, and he worried that absolute power would be the demise of our nation. That consolidated power would lead to overreaching at best and corruption at worst, and he was a fierce proponent of checks and balances. So why does this matter here today in Rhode Island? Why does it matter? Why should it matter to you, my Senate colleagues? Because no one senator, even the Senate President, should be able to thwart the will of the majority. Senators should be able to speak their minds and vote their consciences without fear of retribution, like being removed from a committee or losing their chairmanship. The amendments I propose would allow the Senate President, of course, to remove a senator from a committee assignment or to remove a chair from their chairmanship with the senator's consent. If the senator does something and that can be, worked out and negotiated, I would like to think that most of us, if we ran into a problem or we did something that we thought would cause this august body to look bad, that we would, with our consent, step down. And my amendment also continues to allow the Senate President to remove a senator from a committee assignment and to remove a committee chair without their consent for cause only, and I'm so happy that that language is in there. But what my amendment does is to create the possibility for a check and balance by giving an aggrieved senator or an aggrieved chair the right to have his or her committee fate or chairmanship fate determined, if he or she would like, by a majority of senators. You see, anytime we senators keep our power, we're doing a service to the people we represent and a service to democracy. With our existing rules, I sometimes wonder, in the past, who were the senators who voted to give away their power to leadership, like power to get a vote? I think many of us complain about the inability to get a vote. Well, we're not on that here today. But at some point in the history, we changed our rules and senators gave away their power to demand a vote. And now, of course, we can only get a vote with the blessing of Senate leadership. So today, as senators, on this amendment that I am offering, we have the opportunity to maintain some of our power, meaning that if one of us feels aggrieved by this kind of a decision, you have the right to go to the body. Having been duly elected by the voters of our district, I think that this also represents an opportunity to expand democracy so that instead of further consolidating power at the top, we would have the opportunity to enact a small measure of small d democracy by having this check and balance against potential overreaching. Now, I'm hopeful and confident that we'll never even face this. But rules are your friend when you need them the most, and that's usually when things are not going your way. And ladies and gentlemen of the Senate, I have to tell you that this is not speculation. This is something that many of us in this room witnessed with our own eyes with the swift and undemocratic demotion of former Senator Dan DuPont, the former chair of the powerful Senate Finance Committee, who was immediately demoted from that position after he expressed an interest in running for a leadership position. And swiftly taking away his chairmanship, literally from one day to the next, in my opinion, was sort of a slap. It was a shot across the bow to all of us who might even seek the possibility or the opportunity of running for a leadership position. And it reminded me, and I actually heard colleagues saying this, if you shoot the king, you better shoot to kill, because if you don't, you will be killed. However, we are not a kingdom. We are not an oligarchy, and we are not an autocracy. We are supposed to be a democracy where it is every American's birthright and every Rhode Islander's birthright to run for any office that they choose, whether that is to be a senator or a rep or to run for a leadership position here in the Senate. That is fundamental to who we are as Americans and Rhode Islanders. You know, members of the public sometimes say to me, how is it that so many of you always agree on so many issues that in the Senate are decided either unanimously or near unanimously? And I think a part of it is that some of us are afraid to buck the system and go against votes that are on the Senate floor because we don't want to lose a Senate committee assignment, and certainly chairs don't want to lose their chairmanships. Now, my good colleague and friend, Senator Lombardi, referred to this in committee and again today, for now, my good friend. Nothing that a good bottle of wine can't overcome, Senator. You know, he referred to this in committee and on the Senate floor as the Kettle Amendment. And yes, we all understand what happened with Senator Kettle and the need for leadership to remove Senator Kettle if necessary. But based on what I just said, and I don't want to belabor it, it could just as easily, my amendment could be referred to as the Dan DuPont Amendment. Now, I understand, you know, if somebody after that leadership transition takes place isn't on their team, thwarts their leadership agenda, otherwise is, you know, obstreperous or an obstacle to them getting what they want to get done, to me, that rises to the level of for cause. But ladies and gentlemen of this Senate, let me invite you to think about a time in history in terms of being removed from a committee assignment or a chairmanship. There must have been some time when some uppity person decided to drink from the water fountain of white people, where somebody in a position of power might have thought, this person is way too uppity and we're not going to tolerate that in our society. Now, of course, you know, that's ridiculous now, but there was a time in history when people took that seat on the bus, drank out of that water fountain, and were probably seen by most people in authority and legislative bodies as you know, terribly riotous, if you will. And there must have been another time in history when somebody said, oh my God, did you know he was sleeping with another man? And that shocked the conscience of people, and they thought that that person was a bad person and shouldn't have that committee assignment. You know, we are in a political building. We are in a time of changing mores. Everything we do here sometimes is on the cutting edge, and some bills, as we all know, can take up to 20 years to even get passed. So when things first happen, they may shock the conscience of whoever is in leadership, but if you felt aggrieved, wouldn't you want a vote of your colleagues to be able to say whether that whatever behavior that you engaged in was wrong? And I'm confident that if we had somebody who committed serious campaign finance fraud, this body, all of us in here, would probably vote right along with the Senate President to take them off the Finance Committee. Or if somebody else, serious sexual misconduct, as we have had in here, that this body would go along with our Senate President. But what if it was one of those times where somebody was avant-garde and speaking out for social justice or for some issue that at that time is not popular? Wouldn't you want the opportunity to go before your colleagues? Now, my good friend Senator Lombardi and many of the attorneys in the committee hearing, they talked about correctly the fact that there is a body of law, you know, all about what is for cause. But ladies and gentlemen, if you feel aggrieved by a ruling of the Senate President, do you want a court case or do you want to take your issue before your colleagues in the Senate? Because most people don't want to have to spend money and go through what is very often a 1 or 2 year battle in court to try to get your issue heard about whether the Senate President's actions towards you on the Senate floor were, you know, along with the cause body of law. And here's another thing I will tell you. It is well established that legislatures can police themselves. you know, we have, in talking about checks and balances as I have, it is well settled that we have 3 branches of government that are co-equal. Do you think the Superior Court or the Supreme Court is going to want to jump into our business to look over the shoulder of the Senate President to say whether what he or she did was for cause and was valid? Number one, I will tell you, in my opinion, as an almost 30-year lawyer, our courts are not going to want to do that. Number two, I will tell you that it's well settled law that the chambers are allowed to run themselves and police themselves and to discipline their own members. So although that exists theoretically, that will be, you know, small, of small recompense to a person who might be aggrieved by a decision like that. And most recently, not that long ago, there was a case, the NASW, National Organization of Social Workers, against Harwood in the House, where apparently the then Speaker of the House banned lobbyists from the floor. And people, you know, I don't know if it was the ACLU along with the NASW as an amicus, but they sued, and the court basically said that the House can police itself if they don't want lobbyists, you know, that even that didn't rise to the level of freedom of association or your right to participate in government or anything like that. So in my opinion, you know, if you were an aggrieved senator, if that happened to you, do you want to have the right to a court case, or do you want to have the right to come to all of us and try to explain your situation? So ladies and gentlemen, on this amendment, if you want to keep your power, if you want to be the voice of your constituents, if you want to avoid further consolidation of power at the top, and most importantly, if you want to preserve the checks and balances that are inherent in our system of democracy, I urge you to vote green on my amendment. All it does, it continues to give the Senate President the power to remove committee assignments, to remove chairmanships, but only if a senator feels aggrieved. It just gives you the right to come to your colleagues here on the Senate floor. I don't think that's too much to ask, and I think it's a large step forward in small d democracy, and I move passage.
Senator Nesselbush moves passage of the amendment. Is there a second? A second by Senator Bell. Discussion on the amendment. Senator Bell.
I really want to thank Senator Nesselbush for putting in this amendment. I think it's a really great amendment. And there's a lot in here that I think really will improve our rules, and in particular improve this proposal. Now, I'm not going to speak as much on the substance of the original proposal. I'll do that when we're back on the Act. But I really want to speak to the substance of this amendment. One of the things that happened in the original proposal was that the wording created this problematic issue where it just says, currently, if we don't pass this amendment, it says, provided, however, the President of the Senate may change the committee assignment of a member without the member's consent for cause only, and provided further, et cetera, et cetera. This language does not contain the ability to be removed from the committee with your consent. If we don't adopt this amendment, that right won't exist, which creates all sorts of problems. Perhaps someone can, out of spite, decide to consent to their removal. And so, because it's not without their consent. Now, obviously, that is a technical issue, and sometimes people make judgments about what a reasonable interpretation of the original intent might be. I think the original intent here is to maintain that right to be removed with your consent. But I'm not entirely sure, and potentially, you know, it creates the problem of maybe someone is assigned to a committee that poses problems of recusal. Perhaps you are deeply involved with a number of prominent corporations in Rhode Island that are regulated by bills before the Commerce Committee, and you don't want to sit on the Commerce Committee. Perhaps you are a union executive and you're concerned that there might be potential issues that relate to your union specifically, and you might not want to sit on the Labor Committee. And so potentially, without someone guaranteeing this right, you could be punished. You could also be in one of the issues that I have, and I want to thank the Senate President for taking this into account when he was making my committee assignments, is that it's often very difficult for me to be at this chamber before 4 because I have to work. And certain committees do meet before 4. And if you miss committee meetings, you look very bad to your constituents. And so there's a practical reason why you might need that protection to be able to have the right to be removed with your consent and with the consent of the Senate President. And so I think that that's really important improvement here to the language. Another really crucial improvement is the right to have it decided by majority vote of the Senate. And one of the really great rights that we have in America, one of the things that makes America a free country, is our core right to due process. Because the tenor of this has been changed from just a matter of politics, if you're kicked off for political reasons, it's not a determination that you did something wrong. The for cause language makes this a determination that you did something wrong. If you're accused of wrongdoing in America, you deserve some opportunity for due process. And that's a fundamental principle. It's a fundamental principle enshrined in the United States Constitution, enshrined in the Rhode Island Constitution, enshrined in the history of what makes this country the country that it is. Due process is one of our most fundamental rights, one of our most crucial rights. If you're accused, you need that protection to be able to defend yourself. Because sometimes people are innocent. You could be accused of something you're not guilty of. To be denied the protection, to be denied the right to have some form of due process, to be denied the right to bring it before this chamber, the chamber that in the Rhode Island Constitution is given the power to try contempts. To not have that right is so concerning. Because if I were accused of wrongdoing, I would want the opportunity to defend myself. And I'm sure every other member of this chamber would want the opportunity to defend themselves if they were accused of wrongdoing. It can, of course, any accusation of wrongdoing, any determination of wrongdoing, can have a major effect on our elections. A lot of people in Rhode Island won't vote for someone who's determined to have done something wrong. And that's for a very good reason, because people are concerned about misconduct. And consolidating this power to sit in judgment in the hands of one person, I think does undermine our access to due process. That we would have this fundamental right to due process if we are allowed to vote. And I also want all the members of this chamber to consider the following as you're weighing whether to support this amendment. That what would be the reason to not put this language in? What would be the reason to not grant a right to have it determined by a vote of the Senate? What would be the circumstance where someone doesn't deserve their fundamental right to due process, where they don't already have a process in place to determine these procedures? Now, I do think that when it comes to sexual harassment, we need better policies and procedures, and we need to really think through a long, well thought out, optimal process on that issue. And I hope that we'll address that in a further amendment. And that is an area where I understand that there can be issues of disclosure and things like that. But the right opportunity to address those would be to add more due process, not less. And so I think that this is a truly fundamental decision. It's a decision over whether we want to award senators or award to a single person the ability to make all these determinations. And we want to deny the right to due process to members of this chamber who've been accused of serious action. And this could be applied arguably in the case of an indictment. It could perhaps color that indictment if someone is innocent. And now I want to move on and discuss the final part of this amendment. The current language that we have in the rules on officers of committees does not clarify the removal of committee chair process. It just says the President of the Senate shall appoint from the members of each committee a chair, vice chair, and secretary, and other such committee officers as the President of the Senate deems appropriate. And if we're going to have a process for removal of a committee chair, that should be clearly spelled out. There's a practice for committee chair removal, and it's sort of understood that this language is implied to mean that the Senate President can do that. But if we're going to have that practice, it is better to clarify that in the rules. And I don't necessarily think that that's a great practice. I think that committees should be able to elect their own chairs. But this amendment isn't so radical, and it just provides a simple protection. Protection number one, clarifying it in the rules, so that A, if there is a necessary removal, that power is clarified, and B, again, granting the right to due process, the right to have that issue decided by a majority vote of the Senate. So I think this is a really great amendment. I urge all of my colleagues to vote in support of this amendment, and I will be proud to vote in support of it. And I was proud to rise to second it. And I really want to thank Senator Nesselbush for all the hard work she put in structuring what I think is a really well thought out amendment.
Chairman Conley.
Thank you, Mr. President. I rise in objection to this amendment, and I would like a few minutes to explain why. When we look at the amendments that are before us, but particularly this one, I think we want to establish some threshold standards that should serve as measurements of whether or not we want to proceed with these rule changes, whether or not we should object or support these amendments. I think those basic threshold standards should include ethics, accountability, and transparency. And we understand from recent experience, we understand from the explanation given to us by Chair Lombardi and from the testimony that came before his committee, that the basic thrust of this amendment is for an ethical process, a process that enhances ethics in the Senate by providing a standard for removal from a committee of a senator whose conduct is inconsistent with the mission, the dignity, and fairness of those committee processes. If we have a colleague who unfortunately has engaged in misconduct that is inconsistent with the mission of that committee, we need a means of protecting the ethics of that committee and the ethics of this body. Our recent experience taught us that we didn't have a process that did that. We took care of it in part last session, and now we are completing that process so that if there are ethical transgressions that need to be addressed, the Senate President has the ability to address it. But we don't stop there. This rule also requires that the Senate President be accountable and that it be done transparently by requiring the removal for cause. It requires the Senate President to provide that statement to all of us and to the entire state of Rhode Island of the reasons and basis for that removal. This rule, therefore, promotes the ethics of the chamber by a process which requires accountability and enhances transparency. Now, there's been some discussion about what cause is and what it means. And in reality, our own Supreme Court, and frankly other courts all over the land, have told us repeatedly that it is a phrase, it is a standard that does not lend itself to a fixed standard or bright line. But the court has been helpful in giving us guidelines of what cause means. The reason for cause may not be irrational, unreasonable, irrelevant to the mission of the purpose of the committee, meaning that the cause stated by the Senate President must relate to that senator's fitness to discharge that senator's duties in accordance with the mission of that committee. Although there's not a bright line standard for cause, our Supreme Court clearly in the series of cases that have described what cause is tells us that much. We are holding the Senate President to that well-accepted, well-understood legal standard. Now, there's been some discussion that this process denies due process under the Constitution. And while I do agree that due process is a fundamental right, probably as sacred a principle in civil law as anything can be, that makes it all the more important that we don't misrepresent what due process is. Due process is in Article 1, Section 2 of the Rhode Island Constitution, which tells us that no person shall be deprived of life, liberty, or property without due process of law. What that means and what courts have told us since the inception of the Constitution is that for due process to be engaged, for that fundamental constitutional right to be engaged, then a property or liberty interest must be implicated. Otherwise, due process is not at issue. Now, I doubt anyone sitting here believes that they have a property right to this seat. And I doubt anyone sitting here believes that they have a property right to sit on a particular committee. Likewise, while the courts have told us that liberty interests go beyond bodily restraint and does extend to a full range of conduct, no liberty interest is implicated by removal from a Senate committee. Due process deserves respect, and it shouldn't be misused and degraded in this chamber. But one who believes they've been improperly discharged from a committee is not without remedy. it's been suggested that, well, it's years of litigation. That's really not the case. Representative government's been going on for a long time, actually prior to our Constitution. And even before the federal Constitution, before the Rhode Island Constitution, the common law created a remedy for a public office holder who believed they were being denied their rightful claim to hold a public office. And through the history of the common law, the equitable petition known as quo warranto was recognized. Not only does that remedy exist at common law, meaning a quo warranto petition to seek to be seated in the public office that you have a legal right to hold, but Rhode Island has felt so strong about it that in 1891 it codified the petition of quo warranto, and we not only have the common law right in Rhode Island, but we have the statutory right to file a petition of quo warranto to claim our right to hold that public office. And the reason why it won't go on for years is because in the wisdom of this legislature, it gave direct and exclusive jurisdiction of a petition for quo warranto to the Rhode Island Supreme Court. So if one feels that they have been wrongfully removed from the office of serving on a committee in the Rhode Island Senate, they have immediate redress directly to the Rhode Island Supreme Court through the petition of quo warranto, excuse me. We don't need to substitute a political process in this chamber for a process that has been recognized for over hundreds of years in the common law, codified in the state of Rhode Island in 1891, and is currently available. This amendment will cut against the grain of hundreds of years of common law rights, common law process, would not be based in due process, but would be essentially a contrived political process replacing the fundamental right of due process and abrogating a public official's right to seek remedy directly to the Rhode Island Supreme Court. For all of those reasons, I would ask you all to reject this proposed amendment.
Thank you, Senator Connolly. Senator Oyer.
I rise in opposition to this amendment, and I agree with what Chairman Connolly said. And I also want us to be very cautious in how we're reflecting upon civil rights movements over time. Those movements are hard fought. They are between members who have great power and segments of the population who are greatly disadvantaged. There's a power differential there that does not transfer to a discussion between members of the Senate and Senate organizational disputes. I also would encourage, as any conversations around civil rights are discussed, that we refrain from using language that is harmful to communities. I think often we can think and reflect back on language, but we should not repeat those terms on the floor of the Senate in 2019. Thank you.
Thank you, Senator Oyer. Senator Metz.
Yes, thank you, Mr. President, ladies and gentlemen of the Senate. I don't know if I shared with you, my mother's side of the family is from Virginia, and my great aunt, maybe 2002, 2004, she passed away at 106. So she gave me some of the family history. I know this part of our part of the family, the Speck Plantation. I know what plantation my branch of the family from Virginia came from. And I say that because in my community, you know, we mentioned due process and innocent until proven guilty. In many of my community, we feel we're guilty until we're proven innocent. So we see things from a little different perspective. But what I wanted to say to you, as the second African American in the history of the Rhode Island Senate, do I fear power? No. Martin Luther King, Malcolm X, W.E.B. Du Bois, you name them, they knew their constitutional rights. And for me, I always tried to figure out why with the Jim Crow laws at the time, how my father and grandfather could go and fight in the Second World War. But they knew the ideals of the Constitution. So the reality was here, but the ideals were here, and what they were fighting for was to close the gap. So fear of power, lack of trust, you know, I could have had all of that when I came in here, but you have to have faith in your leaders. And I'm confident that it would only be done in the extreme, because for me, there's loyalty, but then there's integrity. And I'm going to keep the balance. And I say that because I don't want you to get the negative picture of this institution, the House and the Senate. I first came to the House and I was elected in 1983. I was in the House from 1984 to 98. We've come a long way. If you was a rookie, you didn't get any bills passed. Your first term, maybe even you're going into your second terms. Forget it, you wouldn't get no legislation passed. Notification, transparency, there was no electronics. Things were posted up out near the library or outside the committee rooms when they would change the hearing dates. And so transparency, now compared to then, we've come a long way. And I want you to understand that. And voting for leadership, there's been times when I voted against my leadership. If it goes against me, and I've done it in the House, I was on the wrong side of a battle for leadership over in the House. But when people come to me and I've said, and this is how I tell a leader, no, it's not right for my district. And the former speaker, my first speaker, he said, back then there was 100 representatives. He says, all I need is 51. I'm just counting the votes. Because he knew that he could count on me, but if it went against my district, he knew I was going to vote against it. And I still do. It's not going to change. It's not going to, I don't have that kind of fear. And so going against the leadership, sometimes you have to. But all the leaders that I've had over there and over here, they have respected my views on behalf of my district, and I really appreciate it. Most times I'm with them, but there's times when I'm not, and they understand that, and they've never really held it against me. Well, a little bit over there when I was on the wrong side of a little bit. And you know, as far as the 5-minute rule, I've seen people, as Senator Lombardi said, you know, you give people your time. We really didn't have it wasn't an issue with the 5-minute rule until they put the TV cameras in. Oh, look. You know, posting, you know, being able to post the bills manually as opposed to electronically. And, you know, so I guess the real point that I want to make, I'll be voting against the amendment, but I do respect Senator Nelson Bush for fighting for what she believes in, and I know it's dear to her heart, but I don't want you to lose sight of the progress that this, you know, I was 14 years there, I've been 14 years here. 28 years, I've seen a lot. I've seen a lot, but don't lose sight that this legislature has come a long way from the 1984 when I first came here, and I don't want you to lose sight of that. We've come a long way. I'll be voting against it, but I do want you to know that there has been great progress made as far as due process, proper notice, transparency. We've come a long way, so please don't lose sight of that. Thank you, Mr. President.
Thank you, Senator Metz. Senator Seveny.
Thanks, Mr. President. I will say I was greatly relieved when I saw the sub-A and the language adding for cause only was included. I mean, it's a term of art, but it's also very meaningful, and that meaning, I believe, and this is going to lead to an assertion that I would ask if the chairman of the Rules Committee would yield and validate my assertion. It's really a question. But when I look at the term for cause, that's really an action that it exercises the article of faith that we put in you, Mr. President, when we vote for you to be the leader of this group. Okay? Terminating, relieving someone for cause is a leadership function, and in some cases, as we've seen, it can be critical to the organization. And it's a little more complicated perhaps for us because we are, when you boil it all away, a collection of peers. And you, sir, in my view, are the first among equals. So here's my assertion. When I read for cause only, I understand that to mean a couple of things. One is there has to be a really compelling reason to take this leadership action. And secondly, when the leader decides to act, it's with the understanding that he is accountable to the group that he leads. And that accountability that we talked about transparency, that faith is exercised when he comes back to this group and explains, this is the reason why I'm taking this action against this person who, in fact, is a peer, elected just like all of us. And we have the right to question our leader on that act that he's taken. That's a part of the accountability bargain, in my view. So if the chair of the Rules Committee, Senator Lombardi, will yield to a question.
Will he?
Since you already asked a question, I guess I have to yield now.
Okay. Am I correct that that's how this is going to work?
You are absolutely correct. And if I may add, Senator Conley, had given us a constitutional dissertation on the word for cause. But I would also add, Senator, that, and I made issue of this in the committee, is the word only. I think that typically we see for cause. This actually says for cause only, so that it basically says, hey guys, if you don't understand this, it really means that he can only act when it's for cause. And so you're absolutely right.
Okay, fair enough. And I would like to say that I concur for that part of the discussion that I could follow with Senator Conley. I concur. I mean, I'm at a disadvantage here. I grew up in an environment, I spent my formative years listening to terse, very short, very clear communications, and sometimes that's not what we do here. So I just want to make sure I understand. I just want to make sure I understand when an action is taken. The accountability between the leader and the people he leads remains intact, and it's transparent, and it's communicated, and we all get to have a say in that event. Thank you. Appreciate it.
Thank you, Senator 70, and thank you, Senator Lombardi. Senator Nesselbush.
I think Senator Lombardi was first, but did you have your right hand before you answer the question?
It doesn't matter.
Senator Lombardi.
Very briefly, Mr. President, I rise, obviously, and urge my colleagues to reject this amendment, and I thank my colleagues, for Senator Oyer, Senator Metz, and Senator Conley for getting up and really providing us with three very diverse reasons as to why the rules as proposed are valuable rules. But I just want to say very briefly, again, I spoke of the with cause only aspect of this, but I also want to say coexistent with the jurisprudence that Senator Conley laid out for us is this inherent power of the parliamentary procedure that we have as a body, the power to govern ourselves and the power to be an autonomous group within ourselves. And within those 200 some odd years, the principle of a presiding officer has always coexisted with the history lesson that Senator Conley has given us. And I would, just by way of example, look to section 602 of the Mason's legislative rules, which say, and I quote, "It is a general principle of parliamentary procedure that the appointing authority," the president in this case, "has the right to remove a chair or committee member." It's inherent in our jurisprudence. It has been for hundreds of years. And I just want to remind everyone that the president and his staff have chosen to disregard that mandate and to apply a stricter mandate to the Senate president, and that is to remove for cause only. What I want to say, at the risk of ruining my neighborhood, with all due respect to my neighbor, is that this is not a Senator DuPont case. Senator DuPont was not reappointed to the position. He was not removed from his position. A new president took the realm, and a new committee chair was appointed. He was not removed, nor was he demoted. It was just under 602, the president's prerogative to change whomever he wanted on committee chair. But that is not this section. And ladies and gentlemen, the sky is not falling. We are responding to a rather unique set of factors that took place last year that found ourselves powerless under the circumstances of last year. And I just want to give a warning to everybody. If anybody in this room believes that this Senate president during this 2-year period of time is willing to use the for cause only for anything but a cause, is deluded, because the public opinion, this body would not tolerate anything of that nature. So this is a stricter, more transparent standard, and I would urge my colleagues to defeat this amendment.
Thank you, Senator Lombardi. Senator Ciccone.
Mr. President, I rise, and as I look around the room here, there are, I believe, 7 or 8 of us that are still here that remember what took place back in the early 2000s. When you talk about having the acquiescence of the person being removed, that didn't take place then. There were 2 senators, one powerful and one was just as powerful. There was a chairman. And both of them had a problem that brought discredit to this chamber. And it happened during their reign, as one being the chairman and one being the majority leader at the time and then president. What transpired was part of the, I believe, 8 that are still here had a feeling that that person should step down on his own. He refused. I'm not going. I'm not going to step down as chairman, and I'm not going to be removed from the committee. I'm not resigning. What transpired was several months of confusion in here, where the media was here every day, trying to get access to that chairman and ask him what he would do. Finally, after several months, there was relentless movement from the then person in charge, being the majority leader and president, to say, you've created a problem here in the best interest of this chamber, and the members were asking you to step down. He finally did resign. But at the beginning, if it did go to the vote on the floor, due to the fact that he was here for a significant amount of time and due to the favors he done for some of the people here, I guarantee you it would have been a tie vote. So keep that in mind. Sometimes that majority vote will not work. And I thank you.
Thank you, Senator Chacon. Senator Sheehan.
Thank you, Mr. President. I just had some comments on this amendment. I will not be voting for it, but I did have some comments. I thought there was some constructive ideas in there. But on the committee, on that point, removal for cause, although maybe not ideal, I think that's certainly sufficient. And I also agree and concur with my good colleague that I don't believe committee assignment is a due process issue whatsoever. All right. I do agree that chairmanships should not be subject to political whim or wins. But let's not forget, unlike the process that's been outlined by my good colleague, Senator Nesselbush, chairmanships are in fact partisan positions of privilege. They actually go to the majority party, okay, not to just anybody, but the majority party gets the chairmanship and vice chairmanship, and typically secretaries as well, but not always. That's not a steadfast rule, but that is part of the political process that we have, as well as other bylaws and other things you see in Masons and other books. All right, now how to do this? I'll just say that a better process, Mr. President, would be for the chairs to be selected or nominated by party leadership within the caucus, with a majority support affirming the nominee by the leadership of the Senate. And of course, that leadership will be, by definition, somebody in the majority party. All right? And those persons would be picked, those chairs would be picked based upon merit, their experience, their seniority in committee, and their leadership skills. And I would say further that they should not be removed also, except for cause. Thank you.
Thank you, Senator Sheehan. Senator Nesselbush.
Thank you, Mr. President. And ladies and gentlemen of the chamber, I assure you I don't seek to belabor these points, but I want you to know that I agree with virtually everything that my good colleague from East Providence said. Senator Conley, Chairman Conley, spoke of making these decisions with ethics, accountability, and transparency. But let me ask you this. What if there's a disagreement about that? What do I do? So in a moment, I'm going to ask if my good friend, the chair, will yield to a question. Yeah, that will be the answer. But I think, let's assume that I missed 5 committee hearings in a row and the Senate President removes me. Now, number one, I like the Senate President. I consider him a friend. But we can't enact rules because we think he's a nice guy. We have to enact rules that are going to withstand whether this nice guy is the president, or what if my good friend, the chair of rules, gets elected president for some unforeseen reason now. Now we might have something to worry about. Only kidding, only kidding. He knows I love him. But seriously, we cannot, this is not about whether the Senate President is a nice guy or the Senate President. This is about enacting rules for the Rhode Island Senate. And frankly, so I want to ask, maybe I have this common law right of colo ranto. So I get removed from my new committee assignment on HHS for missing 5 consecutive meetings. What do? I go look for a lawyer in the state who knows something about colo ranto? And then what? I file a court case with the Rhode Island Supreme Court? Is that what I want? Or do I want to come? And then what else do I do? If we only have 4 cause and we don't have a vote of our colleagues, then I get removed for 4 cause for missing 5 committee hearings. What do I got to do? Go beg each and every one of you to please go speak to the the Senate President on my behalf because I don't think 5 is the right number. Should it be 7? Should it be 10? If I've learned anything in this building, it's that what some people think is an obvious fact, if you will, you know, I'd look at a hearing schedule and say, we're going to be in and out of there in 10 minutes. You know, this is baseball and apple pie. These are all American ideals. Lo and behold, people show up to those committee hearings and they have an entire different idea of what is baseball and what is apple pie and what is American. So, I want to say about the power differential, ladies and gentlemen, that's why I'm standing up. Because what if a person of color, what if a person who is a member of the LGBT community gets a decision that they don't like? I think they deserve the opportunity to come before this committee. I have stood side by side, I have marched side by side people of color, and it is not right for someone who is not a member of the LGBT community to call out a lesbian for talking about a gay rights issue. That's just wrong. I have stood beside my colleagues in the civil rights movement. I have worked in the women's rights movement. I have worked in the LGBTQ movement. And what is the next frontier? Probably transgender rights. What if somebody showed up to committee? What if tomorrow I decided to present in the Senate as a man and somebody didn't like that and somehow I got removed? Now, this nice guy wouldn't do it, but maybe another person would. We need rules that can withstand scrutiny by ourselves. I have already told you, and the parliamentarian said out loud in the committee hearing, the courts are going to stay the hell out of the Senate's business. Do you think they want their judges messed with? Do you think they want their budget messed with? No. They are going to say that we do have the right to run our own chamber. But ladies and gentlemen, if one of us feels aggrieved, I believe we have the right to go to our members and get a majority vote. A majority vote is the most basic rule of democracy going. Again, you know, when you're ready, we'll take a vote, but that doesn't change anything I have just said.
Thank you, Senator Nesselbush. Senator Bell.
Thank you so much, Mr. President. You know, I've listened to these arguments against the amendment, and a couple of things have struck me. One thing that struck me is that most of these arguments were focused on the arguments for putting in the four-clause language, but not necessarily on why it's bad for us to have this right of appeal to a vote. I think that that's very important. It's an important difference to highlight. I also have to say that I was concerned about the implication that Senator Nesselbush, who is a member of the LGBTQ community, as a lesbian, does not have the right to speak about her community. That bothers me. The implications there are worrisome, they're concerning, because members of the LGBTQ community who are elected to bodies like this one do so because, or one of the important things for members of the LGBTQ community is having representation in elected office so that they can have a voice. And it's important that that voice be able to speak on LGBTQ issues. I also want to address the legal arguments, and I think that Chairman Conley, my friend from East Providence, raised what I think is an important argument for this amendment, although it was phrased as an argument against it, that there is this fundamental right dating back to common law. However, we must remember that we are the state senate of the state of Rhode Island. And the state of Rhode Island has state constitutional provisions, and those state constitutional provisions, and I know I'm not a lawyer, but I believe that those state constitutional provisions supersede common law. I would like to direct the Senate's attention to a very famous Rhode Island Supreme Court case, Irons versus Ethics Commission. This case dealt with an issue where Senator Irons voted on pharmacy freedom of choice legislation while having under the contention, or it was contended that he had a business relationship with CVS, and the frames of his advisory opinion were overly broad. And he chose to bring suit before the Rhode Island Supreme Court and argue that our state constitution's speech and debate protections prevent certain matters from being, quote, questioned in any other place. And there is some immunity from this, and I took the liberty of pulling up the decision just to clarify what we're talking about here. The decision does clarify that certain matters are protected. An example, and hold on just a second here. It relates to the determination of whether something is, quote, a core legislative act. And this is a complicated thing. It's something that I tried to ask about to get clarification so that I would know how to follow our ethics laws. But if there's an ethics violation, even though we closed this loophole and allowed the Ethics Commission to have jurisdiction, that does not grant courts jurisdiction over ethics violations. I would think that ethics violations would be a likely use of this language. At least I would imagine that that would be the case. And so to argue that we have this appeal to courts, I think is, and I know I'm not a lawyer here, but this is a provision of our Constitution, and I do believe it supersedes. We also have another provision of our Constitution, and it relates, I think, to something that the Chairman of Rules mentioned earlier, which is the precedence of rules. And look, not being a lawyer, I said something in committee that was incorrect, and I will fully admit to that here on the floor. I thought that because the argument was made from Mason's rule book, that the rule book itself did not give it the ability to supersede the law. But in our state constitution, and I will be honest here, I was wrong, the state constitution, I went and looked it up, does give the Senate, and gives both the Senate and the House, the ability to determine its own rules of proceeding. And the ability to punish contempts. And I think it could be argued that this is a contempt, and so that right falls within the whole Senate. One might argue that the fact that each, quote, each house has this power means that it's a right that goes to the whole House, and arguably one can make a constitutional argument there that there is a right to a vote of the whole House. But more importantly, were this challenged, I believe that a court would look at that line and say that it is an issue of legislative discretion, that the court will not want to involve itself in the legislature. And there is a long history of legislative deference. And the area where the legislative deference is strongest is an internal process. And here in Rhode Island, I think it bears mentioning that the courts and this Senate have a supportive relationship, and we in the Senate have been very supportive of the courts, and there's a sense that we're all working together, that we're all on the same side, we're all on the same team, and I do not believe that a court would rule against the determination of the Senate President. And I worry that because of that, we would not have due process. And look, I understand without, having been to law school, perhaps there are other legal exemptions that I'm not aware of, but my understanding of the law is that there would be state constitutional problems that could be raised by a court that might deny jurisdiction. And even if the court ultimately ruled it had jurisdiction, it would have to consider carefully the constitutional implications, and that might well delay justice. In a legislative session, justice delayed could well be justice denied. It could be delayed perhaps until after the election, and the senator might not have an opportunity to clear their name. And so I urge my colleagues to vote in favor of this amendment, to grant us due process if we are accused of personal misconduct that rises to the level of being kicked off a committee. And I know I've said this before, but I have to return to this. I hope that we put some trust in members of the LGBTQ community to speak for that community. And that is something that is important to me.
Thank you, Senator Bell. Further discussion on the amendment. Senator Crowley.
Thank you, Mr. President. With all respect to my colleague from Pawtucket, she knows I love her dearly, I think we got ourselves confused here. We have a representative form of government. That means we choose certain people to help us work through our differences and to help us make decisions. This is why we elected a Senate president. If we want a pure democracy, it would be anarchy. Everybody would have their own thing. They all want to be up on that podium. And that wouldn't be a proper thing because we'd not get anything done because we're all little fiefdoms of our own. All right, so we need to have one person that is actually directly responsible to run this chamber. And I'll be voting against the amendment, even though I think Senator Nesselbush has put a lot of work and effort into it, and I know she's a strong advocate for democracy, but democracy works both ways. Okay, we have a city government, we have a state government, and in that state government, we have two chambers, and we have a governor, and we have the courts. We're all supposed to be checks and balances. If the president decides that somebody is not capable of doing their job here in the Senate floor and for cause, then that's his decision. If we're going to have him make all the decisions, then we shouldn't be here. We shouldn't be part of something that he's supposed to do. I respect the president, whether it's Dominic Ruggiero or whoever is the president, for the office and the work that he has to do. We represent our communities and we advocate for that. It's up to him to advocate for this Senate. Thank you, Mr. President.
Thank you, Senator Crowley. Further discussion on the amendment before us. Hearing none, the clerk will please unlock the machine. Those voting for the amendment, please use the green button. Those against the amendment, the red button. Have all members recorded their vote? The clerk will lock the machine. There are 2 votes in favor, 35 against. The amendment fails. On the act, as amended. Senator Nesselbush, thank you, Senator Felag. Senator Nesselbush, you have the floor.
Okay, ladies and gentlemen, my second amendment, if you could pull it up, is LC 00111 5/5. (5/5) is amendment number 2.
6 is up. It's fine. We got it.
Okay. Okay, good. Let me just grab my... So, ladies and gentlemen, the way these amendments come up, you never actually, unfortunately, get to see the full text as I would propose it. You just get to see the amendment. But this amendment has to do with the way we do our elections. Now, anybody who has been here since the caucus and then on our first day knows that I am in favor of using a ballot and not the electronic roll call. And again, you know, all of this has to do with the way we elect leadership. And you know, the truth is that the last time in 2017 when that leadership succession happened, I realized that the insiders knew long before the outsiders that President Paiva-Weed would resign, and they had arranged all of their commitments for the succession long before the rest of us even knew what was happening. Ladies and gentlemen, that's not democratic. Some may say this is politics and this is the way it's always been done, but it strikes me that with a record number of women running and winning office, with a record number of progressives in the Senate, and with a record number of people caring about government accountability, that there is a better and more democratic way. So throughout these rules, there's section 8.1 that talks about the method of voting, and I propose an amendment on that. There's section 11.1, and I propose an amendment to that. And the reason is that, ladies and gentlemen, the proposed rules, in my opinion, would take a very sad and dangerous turn, and a very undemocratic turn, because, ladies and gentlemen of the Senate, the rules as proposed before you effectively supplant a Rhode Island general law, 22-3-2, that has been on the books since 2002. So we would be going against 17 years of a law being on the books. Now, granted, the Senate has not followed that law, but that law has been well settled and enshrined in Rhode Island law for a very long time. And frankly, this statute, and ladies and gentlemen of the Senate, I did have the statute delivered to each of you, so the pages handed it out. If you look, it looks like a memo form. It says to all senators from Senator Nesselbush. And I have printed there for you statute 22-3-2. And if you peruse down the statute, previously they were in bold, but you will see the word ballots about 5 or 6 times. And so it essentially says, that if 19 members calling the Senate to order as provided above call for a nomination for the office of president and shall receive the ballots of the members whose names are on the list, and after the ballots are counted by the clerk, et cetera, it goes on to say that a member violating any of the foregoing, et cetera, or to cast any ballot for president of the Senate, et cetera, et cetera. So it uses the word ballot. Since 2002, we have enjoyed the right to a ballot to vote for the Senate president, not a roll call vote. And you see, I think everybody in this room can agree that voting for people is different than voting for public bills. Do you want to look at one of your colleagues in the eyes and say, I don't support you, I support somebody else? Or do most people sort of, you know, when you see somebody running for governor, do you tell that governor right to their face you support him or you don't? Some people do, but other people, especially in a small family of 38 senators, would sidestep the issue and would rather figure out a way that they can vote their conscience in the privacy, essentially, of a voting booth with a ballot that most citizens are afforded when they go to vote. So, you know, on the opening day, when we didn't vote by ballot, you know, I didn't go Colo Ronto and go file something in the Supreme Court because I care about the Senate and I don't want to embattle us in litigation to decide whether we should have used that or not. But instead, here we are with the Senate seeking to supplant that statute, and I suspect that it will be before us on some sort of a repealer motion this year, that we are going to repeal that statute and go only by these proposed rules, which will take away the right to use a ballot. And now here's the thing. My good colleague, Senator Lombardi, the chair, did say that on the U.S. House and Senate floor, they do use the electronic roll call. And frankly, I would have no trouble with the electronic roll call if we used the ballot, a paper ballot, in our caucus. Once we knew that everybody actually got to vote their conscience, I wouldn't care, once it's been resolved, to come onto the Senate floor and be able to use the electronic roll call. But until we do that in our caucus, then the ballot is our only protection in statute that has been there for 17 years and is about to be removed. And so, you know, some may seek to distract you, ladies and gentlemen of this chamber, by saying that voting via the electronic bulletin board up there or voting via roll call has to do with transparency. But ladies and gentlemen, don't be distracted by that. As I have said, I don't think the public has a right to know who we vote for our leadership. For real people have real feelings and real power over you, and that's why it's very different than voting on public bills. I would respectfully suggest that the real purpose of wanting to enshrine a roll call vote in our rules is not transparency, but it's for leadership to be able to know who voted against them and who voted with them, so that they can reward those who voted with them and punish those who voted against them. Witness Dan DuPont. He got punished. Make no mistake, I think voting on all legislation should be transparent and public, but because of the amount of retribution that goes on in this building, I think that we need to end these practices and allow us, at least in caucus, and if we don't have that in caucus, because that's not before us today, that we don't give up what has been in law for 17 years. Ladies and gentlemen, you have the law before you. You can see the use of the word ballot over and over. Why are we going to go away from that now? Why would we want to do that? Why would we want to? I always say, who are the senators who vote to give up their power? Why don't you want the opportunity to vote via a paper ballot? That's the only way you're really going to know that you got to vote your conscience and that your colleagues got to vote your conscience. And that's the very reason why in the caucus in the United States Senate and the caucus in the United States House uses a paper ballot. If you use a paper ballot in caucus, you know you got the right answer. If you know you got the right answer as to who people really want, you can come on to the Senate floor. And frankly, if we did that, once we get to the Senate floor, I think a roll call vote is a waste of time. Why do we want on opening day, if we had a true voting caucus, why on opening day do we want to go, Senator Archambault, who do you vote for? Senator Ruggiero. Senator Archambault votes for Senator Ruggiero. It takes 3 times the amount of time. If my old colleague Paul Fogarty were here, he would never embrace that. If we're going to abolish something a right that you as senators, we as senators have had for 17 years. If we're going to abolish that right today, then let's at least go to an electronic roll, so we don't have to sit here and say the same thing 3 times on opening day, because that's a complete waste of time. Having said that, and again, remember that the United States House and Senate do not do it that way in caucus, and that's why it's okay for them to do it on the floor. But ladies and gentlemen, I think this, I'd love to say this is the hill I want to die on, but I don't want to die. But this is a mountain I'm willing to climb because it's democracy. Each and every one of you deserves the right to vote for whoever you want to with the privacy of a paper ballot. I believe that today. I believe it strongly, and I'm quite sure I will believe it for the rest of my life. I encourage you to vote in favor of my amendment, which would allow us what is currently in statute, the statute that you have before you, which is to vote for your Senate president via a paper ballot. And I move passage.
Senator Nesselbush moves the amendment LC 001115/5. Is there a second? Senator Bell. Is there discussion on this amendment? Senator Bell, please.
Thank you. I rise in support of this amendment. This amendment, and I think it's important that when we debate amendments, we talk about what the amendments actually do. This amendment is about keeping the language in our rules consistent with our law. And I understand that there's a legal argument that's been made, and that legal argument is an important one. And it is, in fact, the reason why we have to do this through a law. The argument that's been made is one about entrenchment law. The legal principle about preventing actions that can't be undone. And part of this principle is a limitation on what can be done through legislative rules. that one legislature cannot bind a future legislature. Now, I understand that we are a Senate. And often when we think about constitutional provisions, we think about them in reference to the United States Senate. And in the United States Senate, it is, of course, a continuing body. Because of the 6-year terms of the senators, because of those 6-year terms, 2/3 of senators, a majority of the Senate, is returning each time. And so that body continues in a majority of its membership. And so the U.S. Senate is a unique exemption from this fundamental legal principle. However, that exemption exists not to all Senates. It exists, and it is exclusive to a Senate that is a continuing body, as the United States Senate is, not to our Senate. Because of this legal principle, at the very beginning of this bill, it says, resolved, that the following rules be and the same are hereby adopted as the rules of the Senate for the years, and it crosses out 2017 to 2018 and inserts 2019 through 2020. 2020. These rules do not bind the year 2021. They do not bind a future Rhode Island Senate. And so the idea that we would be attempting to put in language that changes and supersedes the law runs into this fundamental principle. There is a very good reason why the opening day statute is a statute, and that reason is precisely because of the principle of no entrenchment. The core legal principle that we cannot bind future Senates in the rules. And it was because of this principle that I felt compelled to follow the law on opening day. And I think it's important, we didn't have an opportunity to do this on opening day, but I think it's important that we understand exactly what this law says. At the beginning, this law, of course, discusses the issue of the senior senator from Newport. And I want to give the leadership credit here for attempting to address this issue because it raises an important point, and I think that their addressing of it is the correct one, but it should be done in statute. And it says at the time, and I want to make clear that this amendment supports and does not remove, I believe, does not remove that language and keeps leadership's improvement. It says at the time specified in 22-317, the Senate shall be called to order by the senior member in continuous service present from Newport. And if there are 2 or more members from Newport of equal seniority of service, then by that one of them shall be senior in age, and if there is no member present from Newport, then by et cetera, et cetera, et cetera. This raises an ambiguous point that leadership has clarified, and I think that's important. I think it's important that we remember this, which is the senior, whether it's the senior senator representing Newport or the senior senator residing in Newport. And clarification of that language is important and is an improvement to this part of the bill. But then we come into the issue of ballots. And here I think we need to separate our issues of policy and law. One can think a law is not a good law, and you still have to follow it. And here it talks about specifically ballots. It says if 19 of the members whose names appear on the lists are present, but not otherwise, the member calling the Senate to order as provided above shall call for nominations for the office of President of the Senate and shall receive the ballots of the member whose names are on the list for that office. Ballots. I want to reiterate that word. And we might not choose to have, we might not like certain words. We might have a policy determination that we don't want a ballot vote. But it says ballot. And I will acknowledge that it doesn't specifically say secret ballot, but I think it is a clear and the plain reading of the law, the plain interpretation, is that a ballot is typically secret. But the process, one could argue that perhaps one might structure a public ballot. And in this case, the ballots were made public, and it's not clear that the law was therefore violated. And it continues to use the word ballot. And shall receive the ballots of the members whose names are on the list for that office, and after the ballots have been counted by him or her and by the clerks of the Senate, he or she shall declare the result. And the balloting shall continue until some person receives a majority of all the ballots. And the person receiving that majority shall be the President of the Senate for the ensuing term of 2 years. And so that's the legal point. I think it's concerning that we're attempting to take a rule that can't bind to 2021 and override the law. We could amend the law instead if we wanted to do this process, and we could follow proper legal procedures. And when we do that, I hope that we can open up and discuss the fact that this law, and this is the law that prevents the Senate President from being removed after the Senate President is elected. Now, I think that issue does merit discussion because of an issue we had in Providence on the City Council, where the City Council President was indicted and could not be removed. But then I also think we have the policy question of whether it's good policy for us to have a secret ballot. And this is, I think, the issue on which I think most members of this chamber object to the secret ballot principle. I think the fervor is strongest on the sentiment that a secret ballot is bad policy. And I understand the argument. The argument is one about transparency, that we should all know how we voted. And it's a valid argument. I will acknowledge that argument. But I think when we make policy determinations, we need to make balancing tests. And there is a real system of rewards and punishments that I thought didn't exist, but I've seen evidence of. And under that system, and more importantly than that, and there are places in which the system doesn't exist, it exists because there's a perception of it. In many cases where the leadership doesn't use it, and I'll give them great credit for not using it, people still say to me that it will be used as a justification for making certain votes. As a justification even for making that same vote that we discussed. That while, even if it doesn't exist, I think we have to acknowledge that people think it exists. And that is what is important. And so for that reason, we should follow the precedent that the United States Senate uses. And Chairman Lombardi is absolutely correct when he points to the United States House and says that on the floor, the United States House makes its vote for Speaker via roll call vote. And he's absolutely correct about that, and I acknowledge that he is correct about that. But in caucus, in the United States House of Representatives, it is not a public vote. It's a secret ballot vote. I remember learning about this when I was attempting to advocate for Congressman Langevin to support Nancy Pelosi for Speaker of the House. Someone I have spoken out strongly in favor of, but she faced opposition, including at times opposition from Jim Langevin. Although he ultimately decided to support her, he was reluctant to do so. But because of the secret ballot vote, his final vote is protected. And there were many votes against Nancy Pelosi on that secret ballot vote initially. When there became a movement against her that faced national criticism, the number of secret ballot votes dropped, but it was still larger than votes against her on the floor from Democrats. In the United States Senate, of course, and I do believe and I understand that part of the philosophy of this rules change is that we want to look towards the House. But I believe that we are a Senate. And if we look for a national model, we should find that national model, take that national precedent from the Senate of these United States. I love the musical accompaniment. We should have that to all of our speeches. If I had thought ahead of time, I might have proposed that amendment. I know. It was an opportune choice. But in the United States Senate, the voting occurs via secret ballot. And the secrecy of that ballot, to use a prominent example, Senator Sinema, representing Arizona, was a member of the Blue Dog Caucus in the House, is a relatively conservative Democrat, expressed her concerns with Senator Schumer and promised to vote against him via secret ballot. But ultimately, that was a secret ballot vote. And she had the courage, and she made that commitment, I think probably because she wanted to demonstrate to her constituents that she was independent of the leadership. But the fact remains that the current practice in the United States Senate is a secret ballot. And I also think we need to understand our history. There is an important reason for laws regulating the organization of the Senate. One of the important things in this current law that is a vital provision is preventing against, it says, the member so calling the Senate to order shall not receive, entertain, or put to vote any motion or question whatever, or point of order, while acting as a presiding officer. And then I also have to clarify, because it goes on to say, and any member violating any of the foregoing provisions of this section or allowing any person whose name is not upon the list to participate in the organization of the Senate or to cast any ballot for President of the Senate, or who shall allow to be used in the organization of the Senate any lists of members not prepared and corrected as provided by this chapter, shall be imprisoned not less than 1 year nor more than 3 years. And I have to clarify that I am not in any way implying that we should be following the letter of that law. I don't think imprisonment is at all a reasonable penalty, and I think it's problematic. But I also think that the reason we shouldn't be following that is because of speech and debate, because there's a constitutional reason to not do so. So I want to clarify, and I want to make myself unambiguously clear. I am not in any way, shape, or form implying or alluding that anyone who doesn't follow this statute should be imprisoned, and I just want to underline and clarify that point. And the reason for that is the fundamental right of speech and debate. But we have to understand our history. That there was a way and there was a time when the organization of the Senate fundamentally changed the history of Rhode Island. When procedure and procedural abuses at the organization of the Senate fundamentally changed the course of Rhode Island history. And I am referring, of course, to the time when our party, my party, the Democratic Party, won control of this chamber from the Republicans. And what happened was that there had been disputed elections. And in the disputing of those elections, Democrats argued that 2 senatorial elections have been stolen by the Republicans, and that the Democrats then needed to obtain 2 Senate seats in order to seize control of the Senate. Bobby Quinn, who had been Democratic floor leader in the Senate, fighting Bobby Quinn of the great city of West Warwick, who had led the Democrats on the floor, who had been our leader and our champion, who led us through the great filibuster. Bobby Quinn had been made lieutenant governor. And he appointed a committee to adjudicate on the results of those elections, and because of the Senate's ability to decide on its seating, decided to seat 2 Democrats. And then Democrats controlling the House and the governorship. We didn't just implement a bunch of great Democratic Party priorities. We also abolished the membership of the Rhode Island Supreme Court, which then held term at legislative discretion. Replaced the Republican Supreme Court with the Democratic Supreme Court that later upheld what the Democrats did on the floor. This is referred to as the Bloodless Revolution. And this is in our history. And it reminds us that there are reasons to lay down strong protections on opening day. That those protections are sacred and they are there for a reason, because they can be used to subvert the will of the people. It is an incredibly important protection. It is one, I will admit, that my political party used to gain control of this chamber. An action that has, I think everyone will agree, changed Rhode Island forever, changed the course of our history, and I do believe for the better. But I cannot forget that it happened as a result of strong procedural abuses, abuses that should not be allowed. And I know that there are many in this chamber who don't want to consider these issues, but I think it's serious. I think it's crucial. I think it's very, very important. And so I really think it is essential that we protect these provisions. I will be voting in favor of this amendment, but I want to stress that the vote on this amendment is not a vote that is as much a legal issue. Because it isn't legally operable, it's more a vote about the appearance of the amendment. And so for that reason, I will be voting in favor of this amendment, and I urge all of my colleagues to do so as well.
Thank you, Senator Bell. Chairman Chacon.
Thank you, Mr. President. As I listen to Senator Bell, I have to agree with him with the part of the not less than 1 year, no more than 3. But before I get to the reason why, we were all at the caucus, and as he read earlier, it said that the names that appear on the ballot. Now, the presiding officer announced who was running for president and called for counter nominations. If somebody wanted to get up and run, they should have put their name in, and then there would have been a ballot for people running. There was no counter nominations, so that made it quite easy. The second part of it is this. Since everyone wants to pick out certain lines in here, it says, if 19 of the members whose names appear upon the list are present, but are not otherwise a member calling to the Senate to order, as provided above, shall call for the nominations of office of president, and shall receive the ballots of the members for office. That took place. There were no names except one. There were no counter nominations, and there was a roll call. It also states that, and let me just find it here. that the people that are voting are senators. I brought this up on I believe a amendment that Senator Nesselbush put in. It says the roll of members as appears by the list of senators shall then be called by the clerk. I sat in that room. As I look around here, I know there were people that in that room that voted that were not senators. They were senators-elect, not sworn in. You are not a senator until you are sworn in by the Secretary of State. So if we're going to talk about who followed this rule, think about what you did that day when you were not sworn in by the Secretary of State on that day. Thank you.
Thank you, Senator Chacon. Further discussion on the amendment? Senator Bell.
I just want to clarify one point, and that was the reason for not putting in an additional nominee. It was a gesture of good faith. It may not have been taken as such, but that was how it was intended, and I hope it is taken that way.
Further discussion? Hearing none on the amendment, the clerk will please unlock the machine. Those voting in favor of the amendment, please hit the green button. Those opposed, the red button. If all members have recorded their vote, the clerk will please lock the machine. There are 2 votes in the affirmative, 35 against. The amendment fails. Senator Nesselbush.
Is now the appropriate time for my last and final amendment?
It's as good as any time, Senator.
All right, well, let's see if we can get it done. Okay, so the LC number is LC 00111-5/6. 5/6.
Senator Nesselbush offers the amendment LC 00111-5/6. Is there a second? Seconded by Senator Bell. On the amendment.
Yes, ladies and gentlemen of the Senate, when the House rules came out, of course, I paid, knowing that I had some issues with our rules, I paid careful attention to them. And when the House rules came out, they, of course, had a section dealing with sexual harassment. And so, I spoke to some of my colleagues about that. I, mentioned it over here in the Senate. And I, like I'm sure many of you, waited for our rules to come out. And when they did, I looked at our rules, and they were silent on the issue of sexual harassment and discrimination. And, in the wake of, or the midst of, I should say, in the midst of the Me Too movement, in the midst of the Time's Up movement, we know that sexual harassment is ubiquitous, happening everywhere, in courtrooms and boardrooms and state houses and companies, et cetera, et cetera. Now, last year, there were serious allegations of sexual harassment in the House, and last year, as has already been discussed here in our chamber, we had our own serious allegation of sexual misconduct by a senator. So we know it's going on. And then I also surveyed the personnel policies of various banks, various law firms, various companies, friends that that I had where people worked, and all of their personnel policies said something about sexual harassment. So, I find it odd, and I find it an omission that we have nothing in our rules about sexual harassment. And so I drafted a very basic rule. It simply says that it is the policy of the Senate to basically maintain a harassment-free workplace, a discrimination-free workplace. And very importantly, my amendment, ladies and gentlemen, simply says that a senator who is aggrieved, either feels that they have been harassed or discriminated against, has the right to file a complaint with the Human Rights Commission or with the Senate President if they would wish. And what's important about that, ladies and gentlemen, is the House rule creates some office that's under the control of JCLS. Now, we all know that the House controls JCLS. They have 3 voting members. We have 2 in the Senate. So the last thing we want is for anyone to have to go to that office. I think they called it something like the Office of Inspector General or something like that. Compliance Office? The Office of Compliance. But that's under the jurisdiction of JCLS, and I think that that is wrong-cited, and I wouldn't want anyone here who was aggrieved to not know exactly what to do. Our rules are absolutely silent about it. And for that person to have to go and have JCLS, that is essentially controlled by the House, be investigating a senator for sexual harassment or discrimination doesn't seem right to me. I think it makes far more sense to just go with the organization that comes in and trains us once a year. And it's simply, you know, we have that training in January. If when things get heated and hot in May and June, something happens to someone, I think everybody in this chamber, male and female, deserve the right to be able to look at the rules and know what they should do. And my amendment is simple. You just go to the Human Rights Commission, and obviously feel free to go to the Senate President as well. I just think it's symbolic, frankly. I mean, I think it's quite odd in 2019 for a set of rules for any legislative chamber or for any organization, frankly, not to have some policy on sexual harassment. And it's very simple, it's very straightforward. I think it's actually not at all controversial. So if you care about sexual harassment, if you know that it's going on and want to make sure that all women and men know what to do in case they feel victimized by it, please vote green in favor of my amendment.
Thank you, Senator Nesselbush. It's been moved and seconded, Senator. Thank you. Further discussion on the amendment? Senator Bell.
This is a very important amendment. And I would challenge any member of this body to put forward an argument that we don't need a sexual harassment policy. It would be tone deaf. It would be, and perhaps, look, perhaps there's some brilliant argument I haven't thought of, but we have to respect the right of people who have suffered from sexual harassment to find justice. In the other chamber, the House that we're seeking to emulate, there was a process, but it had problems, and those problems are addressed here. But it existed because there were problems, serious ones. It's a really serious issue. And I want every member of this body, if you are at all considering voting against this amendment, to consider what that would mean. I also, and I think this is really important, want to draw this body's attention to Part D. Neither the Office of Compliance nor any office under the direct jurisdiction of the Joint Committee on Legislative Services, or JCLS, or the Office of the Speaker of the House shall have any jurisdiction over complaints of sexual harassment alleged to have occurred in the Senate. I want to explain why that's so important. In the House rules, there was a creation of a committee on conduct to address these issues and other issues of conduct. But also there was initially a legislative proposal that would have given the Joint Committee on Legislative Services the ability to hire a person to prosecute sexual harassment and all conduct claims. And because that committee, through having 3 members from the House, only 2 from the Senate, is under the jurisdiction of the House, that effectively gives control to the House Speaker, which means that the House Speaker would have the ability to police the Senate. Now, that bill was dropped, and the Speaker said he had the ability to do it without new legislation. And without these protections in the rules, that would be true. Speaker would have the ability to put senators under investigation. The Speaker would even have the ability, to do this in secret, to put the Senate President, perhaps, under secret investigation on charges that were not true, just to harass the Senate President in budget negotiations. The Speaker dislikes a member of the Senate. Speaker could retaliate behind closed doors. These protections are important. It is one thing to have an accusation in public, but to have no oversight, as the current process allows, is deeply problematic. And it is absolutely crucial that we put in place protections that protect this chamber from abuse of the Joint Committee on Legislative Services. And one of the things I love so much about this amendment is it addresses it in the rules, and it uses the precedence of the rules as an ability to get around this. And for years, we have wanted in this chamber to move beyond a Joint Committee on Legislative Services that is unfair to this chamber. And such legislation has died in the House. What our rules, and this I want everyone in this chamber to understand how ingenious this is. Our rules give us the ability to have our say over legislative procedure. And where our rules supersede, we can supersede the Joint Committee on Legislative Services. That this legal device that is used here is one that can be used to seriously ameliorate what is a very problematic problem. And there are some of us in this chamber who might not agree on these rules as a whole, but I hope that we can come together as a body and agree that the Senate should be treated fairly, should not be seen as the junior partner to the lower chamber, that the Joint Committee on Legislative Services should be made a fair body. And I want to return, in closing, to the importance of us addressing sexual harassment. It's a concern I heard about from constituents, and I want to make sure that we address it. So I urge all my colleagues to vote in favor of this amendment.
Thank you, Senator Bell. Chairwoman Lynch Prata.
Thank you, Mr. President. I rise in opposition to this amendment, and I first take exception to the suggestion that any opposition to this amendment means that any member of this chamber does not take sexual harassment or any allegation of sexual harassment seriously. This chamber takes it extremely seriously. This is an issue that we have already dealt with, that already exists in our rules, specifically in Rule 10.20. This chamber obligated itself previously to training not only for the members of the Senate, but also for the staff to deal exactly with the issue of sexual harassment. This is training that we undergo each and every year. It's explained the process and the procedure by which someone would go by if there was an allegation of sexual harassment. I was here, as many other members of this chamber were, when the allegation of sexual harassment was raised across the hall. I know this leadership team took that very seriously and spoke not only with our members, but also with members of the staff to ensure that everybody understood completely what our process and procedure is. The issue with the JCLS is created by statute and is given statutory authority to be the human resource department of the General Assembly. That's not something we can change by these rules. It's also been made clear that if there is an allegation of sexual harassment, not only is any member or any staff member able to go to the Senate President and to JCLS, they're also able to go to the Human Rights Commission, as it's been made clear that we as members are state employees and can go to the Human Rights Commission. Again, I can't stress enough that this is an issue that this chamber, and I know this leadership team, takes extremely seriously. It's a discussion I've been part of. I've had individual discussions with members to ensure that everybody understands the rules and understands the procedure. Again, I take exception to anybody suggesting that not supporting this amendment means that someone does not take the issue of sexual harassment seriously. It is an issue that we take very seriously. It is an issue that we dealt with swiftly when there was even a concern that there was sexual misconduct that went on in this chamber by a member of this chamber. Again, there is a procedure in place. This is redundant. It's duplicative. There's a rule that already covers it. There's both state and federal statutes that cover it. So I urge the members to reject this amendment.
Thank you, Senator Lynch-Prata. Senator Lombardi.
Thank you, Mr. President. I just want to add very quickly, Chairwoman Lynch-Prata eloquently put it forth, but in addition, there's another in-place protection, and that is JCLS does not act on its own volition. They have private, independent, outside legal counsel ready, willing, and able on retainer to handle such arguments. Thank you.
Thank you, Senator Lombardi. Senator Bell.
I want to read the section that Chairwoman Lynch-Prata alluded to, the rule that supposedly already addresses this. It says, continuing section 10.20, continuing education and training. All state senators and Senate employees shall participate annually in a continuing education program presented by the Rhode Island Commission for Human Rights. Continuing education is not justice. Having a program on continuing education is not a process for justice. And yes, it is true that there is currently this process controlled by the Speaker through the JCLS. And I do not believe that it's a fair process. And I don't believe that the Speaker should be in charge of these issues in the Senate. But I cannot stress enough, continuing education is not a process to achieve justice.
Thank you, Senator Bell. Senator Lynch-Prata.
Thank you, Mr. President. I just want to reiterate that the Senate rules don't provide justice. The Senate rules provide a avenue by which someone can seek justice if they've been aggrieved. The Senate rules provide a roadmap as to how you could seek that justice. They don't provide justice.
Thank you, Senator Lynch-Prata. Further discussion on the amendment? Hearing none, the clerk will please unlock the machine. Those voting for the amendment, please indicate though by pressing the green button. Those opposed, the red. If all members have registered their vote, the clerk will lock the machine. There are 2 votes in the affirmative, 33 in the negative, and the amendment is defeated. On the act itself, Senator Bell.
Thank you, Mr. President. This is a complicated bill. It's a very important bill. It's one of the most important changes we've made to this chamber in decades. There's a lot to talk about, and there's a lot I'm going to be talking about. Yes, and I do apologize to the minority whip, and I am sorry that it gives her and it grieves her thus, but I will be discussing a number of issues. I do want to start by thanking the leadership for what is a serious improvement, a serious move forward, and serious improvement on process. And I do want to acknowledge that because it's important, and that is the proceedings in committee provision at the end of Section 6 that provides this 24-hour sub-A. It's following what the leadership in the House has done, and I think it's an incredibly important change. Section 6.18, substitute bills. And this is really important to me because one of the earliest experiences I had before I was elected as an activist was about voter ID. I felt it was problematic that Rhode Island had passed a voter ID law because I'm a Democrat, and I thought it undermined our party nationally. And then Speaker Gordon Fox had campaigned on sunsetting voter ID. So I thought, let's just encourage a member of the House to introduce a voter ID repeal bill. And I spoke with a member of the House, and he introduced the bill. And I thought, well, then the Speaker will follow through on his campaign promise. And I remember in the hearing, we were told that there was going to be a sub-A. And we were told that the sub-A would remove the photo ID phase-in. So this law was phased in so that in 2012 there would be a non-photo ID allowed, but in 2014 you would require a photo ID. And we were told it was just going to block the phase-in. And I remember watching the bill get passed out right before the vote. Remember Representative Almeida and his indignant speech about how this was not enough. But I felt like it was a fine compromise to accept. But then Steve Brown of the ACLU read the bill and read what had been passed by the Judiciary Committee. And it contained a crucial provision that struck the Board of Elections' ability to add in...
Mr. Leader, what's your point of order?
I'm very confused. Are we debating the bill before this body, or are we introducing...
We're on the amendment, and I encourage Senator Bell to stick with the amendment.
We're on an amendment?
I'm sorry.
Is there an amendment? We're on the bill, right?
Have you offered an amendment, Senator Bell?
Not yet. I will be.
Okay.
But we're on the bill.
On the bill.
We're on the bill until I move the amendment, as I understand our procedures.
Respectfully, I respectfully disagree. However,
Thank you, Mr. Leader. Please proceed, Senator Bell.
And so under this provision, and I want to explain this so people understand why this is so important. Under this provision, the Board of Elections was able to add new IDs administratively. And by striking this provision, it actually meant that this bill, which was proposed as an incremental step forward, would have allowed fewer allowable IDs. And more than that, as the form of identification changes technologically with time, it would have prevented the Board of Elections from adopting using regulations to the time that we live in. So that when we're all on a digital ID, we would be able to use such a digital ID. And so this sub-A gutted the original intent. It made the law worse. And the members of the committee, when they were voting on it, didn't know, because it was passed out right beforehand and they didn't have time to read it. If they did, they wouldn't have voted on it. The chairwoman afterwards, expressed to me how horrified she was that this had passed through. And then the sponsor had to pull the bill so that it wouldn't get voted on and it wouldn't pass under his name, undermining his original intent. And we have today ameliorated that with this language. And I really want to thank the leadership for following the leadership of Speaker Mattiello in the House and proposing this substantive step forwards. But it is not the exact same text as exists in the House. Under the House rules, there is in fact a slightly different text, which I'm going to pull up on the screen here. Oh, this thing. Let's see if this actually works. This is glitching. Well, I'll read this text in our rules first while I pull this up. In our proposal, it says, any proposed substitute bill or substitute of a bill held by...
Excuse me, Senator Lombardi, state your point of order, please.
Point of order is, certainly I'd like Senator Bell, I'm inviting Senator Bell to bring forth an amendment. He has not brought forth an amendment on this particular bill that we're debating.
I understand he's on the bill at this time, which is at the totally proper, Senator, so.
Thank you so much.
Soon.
All times are soon. Any proposed substitute bill or a substitute of a bill held by committee shall be posted at least 24 hours prior to consideration. And I want to pull up the House text here because its difference is important, and this gets to one of my concerns with, and this thing is not working. Oh, come on. Why won't the House rules pull up? Well, anyway. In this language, which is subtly different from the House rules, it says any proposed substitute bill or a substitute of a bill held by a committee. It does not say any committee amendment, which is the language in the House. And this is really important. And I don't think this is the intent. But as things persist, as language persists, over time, this language may well be interpreted 40 years from now by a Senate that doesn't contain any of the original members, and if it does, perhaps those members' memory may have faded slightly. And what it actually says in its text is any proposed bill or a substitute bill held by committee shall be posted at least 24 hours prior to consideration. And this language could be misread to imply that an amendment on the floor that is a substitute bill, which is a common form of amendment that is sometimes placed. For instance, Representative Agello in the House last year moved an amendment that was substituting the House version of the pay equity bill with the Senate version. And I am concerned that this language could be misconstrued, that it could be misconstrued to have that effect. And I know that's not the intent, but I think it is important that we pay attention to the actual language. And as all the lawyers in this room know, the words we use in laws and rules, those words matter. And it goes on to say such postings will be placed on the official General Assembly website as well as on the Legislative Data Bulletin Board. The electronic posting shall be considered the official date of the posting. In the event that the posting is inoperable, then the official posting shall be the Legislative Data Bulletin Board. And this section is, in fact, I believe, subtly different from the House rules, which I have managed to pull up, although this is still an issue with this particular tablet, which, if possible, I would like, if there's someone who could come and help me with making this tablet work, I'd really appreciate that, so I could pull up the House rules. Because I think it is important that this language is different. And so while that happens, I'll move on to another section and I'll come back to this. But I do want to stress that I want to thank the leadership for putting it in. It was a show of good faith, and it's not one that didn't mean anything to me. It's one that mattered. And if it were not for some of the other changes in this bill, if it were not for, could you pull the full rules up without the, if it were not for those issues, issues that rise to a level that is greater and larger and more problematic than this, then I would be voting in favor. And I understand that we need to weigh this with respect to the positive changes. But I want to talk about some of these changes. And unfortunately, we didn't have the opportunity to view in committee many members of this body who didn't have the opportunity to attend the committee could not watch it after the fact. And could not watch it after the fact because there was no official video recorded by Capital TV. Because there was no official video recorded by Capital TV, and because the journalist who was there recording video had an unfortunate data glitch where the video was not preserved. Because of that, members of this chamber were denied the opportunity to view the debate on this bill. And it was a great debate. There were a lot of really important points that were made, and I think members of this chamber would have benefited from having had the opportunity to view the committee hearing before coming to the floor. I know I have. On multiple occasions, I've watched committee hearings, and they've changed how I think about how to vote. For instance, I had some concerns about Judge Darrigan that I'd raised publicly. But during that committee vote, she and that committee hearing, I apologize, during that committee hearing, she addressed those concerns, and she addressed them to the satisfaction that I felt comfortable rising to support her nomination. And I did so because we had an opportunity to view that in committee, and that committee, the Judiciary Committee, was filmed. I couldn't attend it for work reasons. And sometimes we're in committee, and we can't attend another committee because we have things that are being heard in our committees. And so it is so important that we have the ability to view what went on in committee. And the language that's here in the rules is on the very last page, page 30, for everyone following along. It says, "It is declared to be the policy of the Senate that to the maximum extent possible, Senate votes on public bills, elections, and proceedings on the floor and in committee shall be recorded." I know this is important. Or video screened and published on the General Assembly website and or broadcast on Capitol Television. And before I went through this learning experience in committee, where we had a great debate, where I said something incorrect, and then I went back and I learned the law, and I learned that we have the ability to, in our rules, supersede the law on the JCLS. I thought we were confined to this language. I thought we had no ability to go further. I thought that because of the JCLS law, because it's all run by the JCLS, we didn't have the ability to supersede their budgetary decisions and their management of Capitol TV. But that is not the case. And this current language is thin. It just says that it is declared to be the policy of the Senate that to the maximum extent possible, these votes shall be recorded by a video screened. And it even says recorded or video screened. Language that is open to perhaps argue that if it's video screened, it doesn't have to be officially recorded. This language needs to be rethought. It's not going to be the subject of an amendment I'm offering, but I'm concerned, and I would have been concerned with the original rules if we had not made reforms. One of the things I promised was that we reform parts of the rules to increase transparency. And one of the things I've heard about time and time again is that in the Senate, some of our hearings aren't video recorded. To me, this is crucially important. One of the premier journalists in the state, Ted Nesi, posted on Twitter that he hopes that this will be the year when Rhode Island finally, or when the Rhode Island State Senate finally finds a way to put all our committee hearings on video. And it is important that we have to address this in the rules, because our one mechanism for superseding the JCLS is our rules. And so this is concerning. It also says that, and it is limited. It says Senate votes on public bills, elections, and proceedings on the floor. But it doesn't say the whole Senate session, and nor does it say, crucially, the entire committee session. So that is one section of the rules where I believe that we need improvement. And at this point, I do want to reflect a little bit on how we think about transparency. And if we had had the opportunity to view all view the video of the committee hearing, then we could have seen what I thought was a really important point that Senator McKinney brought up. And that was that the way we look at these rules votes stems from our philosophy on how we think about this chamber. Our philosophy, how we think about transparency, the leadership, and whether we trust the process. I think that's a really important point. I'll be returning to it because I think it really helps frame and clarify what we're debating today. Because to me, I believe that the people of Rhode Island want more transparency, are not satisfied with the existing level of transparency over our legislature. But I've heard opposing views. Upon being elected, I was told that we're part of a family. And in a family, certainly we all know there are some things that we don't want transparency about. I was told, and I understand that institutions can start to believe in themselves, believe that the institution does a good job, and it is difficult for an institution to not come to believe that. But I take a different view. I take a view that there's a reason why the people of Rhode Island are upset with our lack of transparency. I take a view that we should listen to them. And look, I know I'm only elected to represent one district. And perhaps there's something in the water in Providence beyond lead. Perhaps the people of Providence are just somehow different. But I don't believe that. I do believe that the people all across this state want us to reform these rules to move towards transparency. And so I do want to move and discuss the switch to Mason's rules. In principle, I think that this is a fine change. But while it is true that Mason's rules are written for legislatures, we have been using Robert's rules for a long time. And when we make a change like this, it is important that we help members of this body understand the ramifications of that transition. We provide copies of Mason's rules, that we provide trainings on the differences. And I haven't heard that that's going to take place. I hope it will. But if we're going to make such a fundamental change, we need to work hard to help this body address that fundamental change properly. But more concerning is what is being implied. What is being implied by us switching, as we do in so many cases throughout this proposed bill, to language in the House. Much as, when I was knocking on doors, I heard stuff about the Senate and calls for transparency and better processes in the Senate. I heard over and over from constituents about concerns with the process in the House. I was told so often by so many members of this chamber, by the leadership, by so many people here, and I believed it, that one of the fundamental principles, one of the great things about this chamber is that we are not the House. And we do not want to run things that way. And this philosophical principle that we want to become the Rhode Island House of Representatives and that we want to do this change and make this change on process, on everything that the Reform Caucus fought against. That rather than supporting the effort of the Reform Caucus, we're proposing to go further. We're proposing to consolidate power in our rules in the Senate President and to copy the House. Upon early conversations, even before getting elected, I thought that this chamber prided itself on being the Senate, on being a deliberative body, a respectful body, where we debate with decorum, where we run things in an open way, where dissenting voices are heard and heard respectfully. And that was a point of pride for me. Pride in this chamber, pride in the Rhode Island State Senate, that we are different, that we are not the House, that we do not run things that way. And yet, throughout these rules, we are proposing to change this process, to change our rules to mirror that House. And that's concerning to me. Not only are we endorsing the process in the House that has been so concerning to the people of the state, but we're losing our identity as a chamber that holds ourselves to a higher standard. We see this all over the place. Perhaps no more important than with the issue we've already touched upon, removal from committees. I remember at the Common Cause banquet, sitting at a table with a number of former representatives who were complaining to me about the process in the House. And their number one complaint was being kicked off committees, was how that process is abused. I was in the room in the Judiciary Committee when the Ethics Amendment was moved forward out of committee, a bill that the House Speaker had previously introduced by former Whip Patty O'Neill from the great city of Pawtucket. Patty made a motion, and in his motion, he moved the Ethics Amendment bill, and it was seconded by Republican Representative Doreen Costa, and it was approved by the committee. And then there was an argument about interpretation of the rules, and it was said, oh, definitely not. This is definitely not moving onto the floor. But more importantly, I saw Representative O'Neill removed from committee the next day. After the leadership transition, there was more punishment. Members who had supported different leader were removed. And that was concerning enough in the initial version that we were copying the House on this. But it rose to another level when the words "for cause only" were inserted. It's one thing to be removed from committee for political reasons. It's one thing to be subject to political punishment. That's politics. I get it.
Please state your point of order, Mr. Chairman.
Okay, and I'm sorry to interrupt my colleague yet a second time, and there's been no amendment brought forth, and what I deem to be an attempt at a filibuster here, and pursuant to Rule 7.13 entitled Interruption of Debate, I think I have the right to interrupt the debate and call the question at this point, Mr. President.
Senator Lombardi makes a motion to call the question. Is there a second?
Rules, which you are allowed to interrupt a floor speech for. We have a right to the floor. The right to the floor, I do not believe, allows a call to question. Let me just find the right to the floor so that we know this. I believe it's beginning of section 7. But there's no debate, only if the motion...
To move the question is non-debatable. Is there a second? Second by Senator McCaffrey, Senator Lynch-Prada, Senator Conley, Senator Gallo, Senator Chacon, Senator Lombardo, Senator Crowley, Senator Metz, Senator Morgan, Senator Archibald, Senator Paolino, Senator Dela Cruz, Senator Rogers, and Senator Bell. The clerk will unlock the machine. Clerk will lock the machine. There are 33 votes in the affirmative, 1 in the negative, and Senator Lombardi, would you be amenable? Would you be amenable to Senator Bell offering his amendment at this time?
We've been waiting 15 minutes. Absolutely, Mr. President.
Senator Bell, if you would like to offer your amendment at this time, the question has been, they moved the question and it's been seconded and it's been voted on. If you would like to move your amendment at this time.
I would like to, yes. It is LC 00115-2.
Senator Bell offers the amendment, LC 00115/2. Is there a second on the amendment? Second by Senator Nesselbush. Discussion on the amendment. Senator Bell.
Am I allowed to speak on this?
On the amendment, you can speak, yes.
Okay. This amendment relates to the time limit that is being removed, the removal of the, in the text that's been brought forward, we would lose our protection, one of our most fundamental protections, that we cannot be interrupted while speaking because a 5-minute time limit would be imposed. This amendment removes that protection. And one of the most important things here is our right to the floor. The senator shall recognize shall not be interrupted while speaking except by a call to order or a motion to suspend, section 3.5. That we cannot be interrupted by a call to question. And because we cannot be interrupted by a call to question, there is a right to a filibuster in the Rhode Island Senate. Now, I don't believe that there are the votes to sustain a filibuster, so I was merely intending to speak for a long time. filibuster, of course, must be sustained if there are enough votes to vote down a cloture motion or a call to question. But I'm going to continue to hold the floor on this amendment, and if the Senate President wishes otherwise, he may attempt to call me to order and say it is out of order for me to hold the floor and to hold that interpretation. And I understand that that's his right, but I don't believe I'm out of order. I've attempted to stay in order. And I think it would be a disservice for this amendment for me to limit myself to 5 minutes.
President.
State your point of order, Madam Chair.
Thank you, Mr. President. Based upon my colleague's indication that he intends to keep the floor and remain talking unless and until the Senate President interrupts him, pursuant to Rule 7.13, I'm asking that we we fix a time for this debate.
There's a motion that we fix the time for debate, seconded by Senator McCaffrey, Senator Connolly, Senator Goodwin, Senator Gallo, Senator Lombardi, Senator Crowley, Senator Pearson, Senator Morgan, Senator Archibald, Senator McKinney, Senator Rogers, Senator Coyne, and Senator Seveny. Is there a suggestion how to, is there a time frame here?
And based upon the hour, I would suggest that we fix a time of 8 p.m. to complete the debate.
Senator Lynch-Prada suggests that the time be 8 o'clock, that we fix debate at, seconded by Senator Crowley. All in favor, please indicate by voting in the green. Those opposed in the red. The clerk will unlock the machine. If all members have recorded their vote, the clerk will lock the machine. There are 31 votes in the affirmative, 2 in the negative, and the motion passes.
I would like the chair's interpretation of whether I still have the floor, or what is the chair's interpretation on that?
You have the floor at this time, Senator.
Thank you. Well, I disagree with what happened, and I'm concerned with it. It's not my intention to be disruptive in any way of this process. It's important to me to maintain decorum. But I do believe that we have a right to speak without limitation. A right that, if it can be sustained, is a right to a filibuster. And it was even stated earlier that one could filibuster by passing on in the sort of chained way through continued 5-minute yielding of the floor. And that right to the floor is crucial to it. It's an important tradition in this chamber. It's one of the things that separates us from being a house. But it is true that all matters are ultimately decided, rulings of the chair are decided, and that is the nuclear option, and that's just what happened here. That's how it works in the United States Senate. That you can supersede the rules, ignore the filibuster rules by appealing to a chair or making some determination, and it just carried because of the vote of the body by majority. And that's what just happened here. And that's concerning. It's concerning because while I was intending to speak, everyone knows that I don't have the votes to sustain a filibuster on this. It's concerning because the filibuster hasn't been used in this chamber in a very long time. And to use that procedural motion before there even is a filibuster is an aggressive and authoritarian use of power, and it disturbs me that there are members of this chamber who voted to sustain that. Now, I'm going to sit down because if someone else wants to speak on this now that we have had a timeline, I do want to grant them the ability to do so. But I have to underline the gravity of what just took place here. how concerning it is and how much it undermines the argument that I will admit I myself agreed to and echoed on this floor, that one of the reasons to vote for Senator Ruggerio for President of the Senate is that he has openness on process, and that process is where we do well. I was wrong, and I'm sorry for that.
Thank you, Senator Bell. Senator Satchel.
Thank you, Mr. President. I voted no on the motion, and I stand up in support of the amendment. The 5-minute rule was one of the sticking points for me. You know, as a history teacher, I always try to look at the background of things and the history of things. And Senator Bell mentioned fighting Bob Quinn like an hour and a half ago. He kind of stole my thunder. The filibuster was used by Robert Emmett Quinn, senator from West Warwick, who was also a governor and lieutenant governor. That's how the Democrats came to power in the Rhode Island Senate. You know, the 3 young mavericks stood up and staged a filibuster in 1924, June of 1924. And they basically talked long enough to make all the Republicans leave, and that's how they took over the government. Felix Taupin, who was a senator from Woonsocket, was reading from Encyclopedia Britannica. He was quoting Hamlet. You know, so I always, like I said, I'm a social studies teacher. I understand what the filibuster is all about. I think that it's something that should stay there, should it ever need to be used. I was looking forward to my own filibuster last year. I was going to tell everybody about TF Green when we had the airport vote. That would have been wonderful. But again, I don't really like the limit on the speech. Many of you know how passionate I am about West Warwick, and if I start talking about things that are happening in West Warwick, I could probably go for like 15, 20 minutes. Easy. But I don't want to have to beg other senators for their 5 minutes to do that. If I'm up here and I'm speaking passionately about something that I really believe in, or I'm trying to relay a point to my colleagues that I really think that they need to know or they really need to understand, I want more than 5 minutes. Now, I've been told by members of the Senate that you guys like me and you'd probably give me those 5 minutes, which I appreciate, but you like me until you don't. And what's going to happen when nobody's going to give me their 5 minutes? And that's where I'm coming from with the 5-minute thing. You know, I've talked to leadership about it. I've talked to our colleagues about it. That, as weird as it seems, is my big sticking point with these rules, and it's something that I would like to see change, and I just wanted to get up and relay that to everybody. So thank you, Mr. President.
Thank you, Senator Satchel. Senator Chacon.
Announcement, Mr. President.
Announcement.
Yes.
Just a break in the action.
Breaking the action. Due to the lateness of this, the Senate Labor Committee, the hearing for tonight will be rescheduled, and the people that were waiting so passionately have been notified, so it'll be rescheduled and they'll be aware of it.
Thank you, Senator Chacon, for that information. Senator Metz?
Yes, I just have to mention that there was a new young preacher that came to this church, and the deacons told him, they said, you can preach as long as you want, but we go home at 1 o'clock.
Senator Goodwin.
Mr. President, just for the Senate's edification and information, all of the Senate committees have been canceled tonight, and they want to bring that online now. And all of the witnesses that were here, few that ever remained, have been notified too. So just so that the committee members know. Once we finish the debate, the session will be over.
Thank you, Madam Whip. Senator Chairwoman Gallo.
Thank you, Senator Goodwin. I just was going to make the same announcement about the joint finance education meeting that was supposed to take place. And I apologize to all the teachers and the preschool students and all those parents that have been waiting for democracy to happen up in 313 since 4 o'clock. 4 hours later, they're not going to get that. However, I hope that they do come back and get their day.
Thank you, Senator Gallo. Senator Nesselbush.
Thank you, Mr. President. I'll be very brief. I do rise in support of Senator Bell's amendment, and as my good colleague from West Warwick said, the filibuster hasn't been used since 1924. I'm not sure I actually completely understand what a filibuster is and when it is needed, but I also wonder if Minority Leader Algier and our president were around in 1924 when the last filibuster happened. I know they're the oldest members of our chamber. And I thought that Senator Chacon might be standing up to announce that he had ordered pizza, but alas, I try to bring a little levity to the situation. Hot wieners. I do stand to support my colleague Senator Bell, and essentially it's for all the reasons that Senator Satchel said, that, if somebody feels that, we are like a family. We're 38 members, and if somebody really does feel that strongly, I think we owe it to them to listen to them and perhaps not move forward with something and not move forward with a motion for cloture until the Senate takes a pause and perhaps on another legislative day decides if all of us really do want to close the debate. But I support the amendment, and that's all I have to say. Thank you.
Thank you, Senator Nesselbush. Senator Golden.
Thank you. I just wanted to take a couple of moments to thank all the people who were here on my bills this evening to eliminate the tip minimum wage, and those who have been waiting for hours to testify in Labor Committee on raising the minimum wage, as well as all those teachers and family members who have been here to talk about universal pre-K, and those other bills that have been about fossil fuel facilities and improving our environment, all of which have been things that people have been waiting for hours to come talk to us all about. I don't actually think this is a moment of levity. I think it's really important for us to have these discussions, but to do so that is respectful in the way of all of us in this room and all of the people in this state who come up here to talk to us every day.
Thank you, Senator Golden. We are on the amendment. Is there further discussion on the amendment? Hearing none, the clerk will please unlock the machine. If all members have cast their vote, the clerk will lock the machine. There are 5 votes in the affirmative, 30 in the negative, and the amendment fails. On the act as amended. Senator Satchel.
Thank you, Mr. President. I will be brief. As I mentioned, my big sticking point, as strange as it sounds, with these rules was the 5-minute limit. But I'm also rising to announce that I'm going to vote no on the rules. And I'm going to vote no on the rules because while I appreciate all of this debate and I appreciate what we're trying to do with the rules, 2 months from now we're going to vote to suspend 3/4 of them. And I'm usually one of the only people that votes no to suspend the rules. And that's something that, again, I just wanted to bring it up. I'm going to vote no on the rules because we're going to have the rules for about 2 months, and then we're going to vote to suspend some of them. And I don't really ever remember talking to any member of this Senate that likes the way that things go down in June, that likes the late nights, that likes some of the horrible legislation that comes across our committees in late June, late at night. So I just wanted to bring that to the attention of the body, and I'm going to be voting no today, and I will be voting no to suspend the rules later in the session. Thank you.
Thank you, Senator Satchel. The act has been moved and seconded. The clerk will please unlock the machine. If all senators have recorded their vote, the clerk will lock the machine. There are 32 votes in the affirmative, 3 in the negative, and the resolution as amended passes.